Number 25, today's listener. We have been submitted affidavit on Friday, man. They prefer some time to file a reply affidavit. Well, it is that case, man, where the salary was paid for as per 8 commission, 7 pay commission for 3 years, then they well, went back to 6 pay.
Mr. Goswami, I don't grant an adjournment in this type of request. You say that you have difficulty today, I'll grant you an adjournment, but not on that ground.
Well, we wanted to give a reply affidavit.
That is your
And
lookout.
not only respondents.
Then wait for your turn when the matter reaches.
And also, man, not only respondents have filed affidavit.
We'll see when the matter reaches.
Fine.
Hey, please, Lordship, I beg to mention Lordship, item number 15 and 44. On behalf of Mr. DK Jain is unable to appear today due to some relative was expired over telephone information.
15 and
15 and 44.
at the request of the learned counsel appearing on behalf of the petition, item number 15 to be listed after 4 weeks. As regards item number 44 to be listed after 4 weeks.
Deeply.
Meet with your lordships. My lord, I beg to mention item number 58, my lord, review petition, 58, my lord. Can it be taken at 2, my lord? 58, my lord, review petition, my lord.
Item number?
58, my lord. Supplemental list.
Why?
At 2, my lord,
Why?
for upgradation, my lord.
Why?
My lord, there is some urgency, my lord, in this matter, so.
What is the urgency?
My lord, although the bid has not yet opened, my lord, but that might have opened, my lord. So my apprehension, my lord, the matter may not reach, so, my lord. At 2.
This review petition is in view of site visit
Yes,
certificate
my lord,
not being opened.
my lord,
Okay, we'll have it after the motions.
my lord. Okay.
May I please, Your Lordship, my lord, I pray for listing of 2 motion matters which were filed on 18, 11 and 21.
Friday?
Friday, my lord. Acknowledge, my lord.
Lordship, for motion matter, your lordship, on 1911, your lordship.
Friday?
Friday, lordship. Monday, lordship, next Monday.
Oh, then it matter, let it come up whenever it is.
Sorry, lordship.
Next.
Sorry, lordship.
May I please, your lordship? Lordship, I beg to mention item number 13 and 14, your lordship. Lordship, I have instructions to withdraw this instant writ petition, your lordship. Lordship, during the pendency of writ petition, lordship, petitioner died, lordship, on 30/9/2024. Lordship, and I have contacted with the legal years. They are not inclined to get subsidy. Item number 13 and 14.
So,
Matter was pertaining to non-payment of contractor's bill, your lordship. The petitioner died during pendency of writ petition.
then
Then lordship, I have contacted legal year. Legal year is not inclined to pursue the matter. I have instruction to withdraw, your lordship.
Mr. So-and-so,
Disposal by-
the learned counsel appearing on behalf of the petitioner submits that the petitioner had expired. He further submitted that he had contacted the legal representatives of the petitioner who are not inclined to pursue with the instant proceedings. Taking into account the above, the instant writ petition therefore stands abated and closed.
Deeply, item
13 or
number
14,
13 and
Peter.
Lordship, mentioning for listing on Friday, madam. 2021 contempt matter, lordship.
Contempt?
Contempt matter, lordship.
What is there?
Non-payment of dues, lordships.
No, Monday.
Lordship, I have filed an IA under section 17B of the Industrial Dispute Act on 29th of October, but till date it has not been listed. It may come up in any date as per the convenience of the court.
When?
Uh,
When do you want?
It's the next.
Any date in the next.
Lordship, I have one more prayer regarding item number 26. Because of some personal medical urgency, it may be adjourned, Lordship, for 2 days only.
What is the matter about?
The registration of the trade union.
Okay. At the request of Mr. FZ Majumdar, matter stands adjourned to be listed after 4 weeks.
May I please, your lordship? Lordship, I pray to mention item number 45. The youngest counsel for the petitioner, G. Bora, is out of town, your lordship.
What is the matter about?
Lordship, the youngest counsel for the petitioner G. Bora is out of town, your Lordship.
There are
The
two
matter may be
councillors.
adjourned.
Miss Mdeka is there.
Lordship, Lordship,
Item number 45, there are
45,
two
Lord.
councils.
Lordship.
Then, what about the other council?
Lordship, she has taken instruction. She has taken instruction.
Huh?
Lordship, she has taken instruction.
For what?
She is out of town, your Lordship. The matter may be adjourned.
45 to be listed after 6 weeks.
Lordship.
Please, your lordship.
Highly-
With regards to item number 37, my lord. Lordship, we may be given some time to file our reply, my lord. Respondents have filed their affidavit in opposition.
Madam, how many times should I say that I don't grant these type of adjournments? Whenever a matter reaches, you make this up.
Like this is your lordship. Lordship, I beg to mention item number 2 of the daily list, lordship, for withdrawal, lordship. Not
Withdraw?
Complied with, lordship.
What is your name?
J. Lotha, lordship.
Mr. J. Lothar, the learned counsel appearing on behalf of the petitioner submits that the order dated
24/10/25.
24,
10/2025.
2 days back. What is the order dated? Now file to the action item 2. Mr. J. Lothar, the learned counsel appearing on behalf of the petitioner submits that the order dated 24/10/2025 passed in WPC number 2320/2025 has been complied with.
Complied with, lordship. Yes, lordship.
Has been complied with, and as such, the petitioner would not like to further pursue the instant contempt proceedings. So taking into account the above, the instant contempt proceedings stands closed.
With pleasure.
May it please your lordship, I am for the petitioner in WPC titled Hunmoni Phukan versus the state of Assam and others. The matter was filed on 24/11/2025. I respectfully pray for listing of the matter for motion on Friday.
Friday?
Yes, your lordship.
For motion item 1.
The direction of this honorable court is at page 11, your lordship. Number 7.
Where is the counsel from PHE? Any counsel from the PHE?
Outside of the court, I made till back, my lord.
We'll see when we'll get hold of a counsel from PHE, okay? We'll pass orders.
3.
Yes, Mr. Manan?
The gist of the matter here is that the petitioner was allotted with a contract for laying of cables, optical cables, and then that was in district of Achar for 23 kilometers. I'm giving the gist. And then ultimately, your lordship, after laying down of about half of the around 11.6 kilometers, there were some problems.
They have terminated your contract.
There, but what has happened after termination, they have issued the letters where they've justified my view that we could not lay the cable the other part on the ground that there were some gas pipelines and water pipelines, and secondly, there was a national highway, there was a part where it's under the national highway, and they have not taken the permission from them. And this was subsequently, always after the termination, that letters were issued to me. I have annexed those letters, your lordship, and they have justified my, and therefore. Your
Where is the
Lordship,
termination?
termination, but ultimately, your lordship, they have not changed to challenge the termination. The only part is that the amount, the part that they have completed, They have asked for payment of that.
No, you are asking against the invocation of the bank guarantee.
That is also.
Isn't that one of the conditions for once it is terminated, they may invoke the bank guarantee?
They have invoked the bank guarantee.
So you don't know, you are giving up that plea.
We are giving a bank guarantee. and
But if you are
partially
not giving up the plea, then are you not therefore required to challenge the termination?
Is it actually what has happened? I have gone through the petition. In the, I have stated that you should have challenged that, but they have
Then-
in fact not challenged that.
then- Withdraw and file a fresh one.
That would be a better option.
Because without a challenge to the termination, you cannot challenge the invocation.
Been engaged later on in the matter. And we have also filed.
Your name glaringly appears from the first date on 27/8,
Terms
4
and
months back.
conditions.
4 months back,
Yes.
you have been appearing.
But then now what has happened, your lordship? They have already issued the advertisement for the remaining part of the work and that has already been sent.
So that is okay, but unless you challenge the
Exactly.
legality of the termination, then only the consequential effect. Yes, it may be that you may not challenge the NIT, the fresh NIT, but if the termination is held to be illegal, then only you can get those effects.
So to withdraw with the liberty.
Mr. Y.S. Manan, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would be well advised to also challenge the termination, the illegal termination of the contract by the respondent authorities. And as such, in addition to the cause of action for which the instant writ petition has been filed, he therefore submits that the petitioner may be permitted to withdraw the instant writ petition with the liberty to refile by challenging the termination as well as the other causes of action for filing the instant writ petition. So taking into account the above, the instant writ petition stands closed with closed. However, liberty is given to the petitioner to refile by challenging the termination in addition to the challenge which have been made to the present petition.
Right.
Mr. So-and-so, so-and-so, so-and-so appears for so-and-so.
Then
Give
may
your
I-
names. Hey, wrong with you? Yes, you find out what is wrong. This is an application filed for alleging willful and deliberate violation to the order dated 28/10/2024, passed in WPC number 2243/2022, whereby there is a direction passed by the learned coordinate bench of this court to verify as regards the entitlement of the petitioner, and if the petitioner is found to be entitled to make payment within a period of 3 months. It is seen that in pursuance to the said order on 8/11/2024, the petitioner duly submitted the certified copy of the said order before the chief engineer, PHE Assam. However, as the no steps in that regard has been taken, the petitioner have therefore filed the instant contempt application. This court have requested Mr. I. Botaku, the learned standing counsel of the PHE department, to inquire as to whether the order dated 28/10/2024, passed in WPC number 2243/2022, have been duly complied with or not, Full stop. The name, a copy of the instant contempt application be provided to Mr. I. Botaku, the learned standing counsel of the PHE, during the course of the day. The name of Mr. I. Botaku shall also be reflected in the cause list as the standing counsel of the PHE. Full stop. List this matter on 15th of December 2025 for an update in the motion column.
Item 4.
Shareholders of 769 of Rangpur. What is this? At the request of the matter stands adjourned. Means you have a bad case.
The license of that petitioner society has been cancelled by long back, it is in the year 2022. No appeal was filed. It is barred by limitation, means within 30 days, we have to prefer an appeal. In the meantime, the FIR which has been filed has been closed, my lord. The FR, the police has given FR and the case has been closed, my lord. So now we have come, my lord, the license to be restored, my lord. license, sub wholesale license in favor of the cooperative society is required to be restored, my lord.
File appeal.
The appeal is already barred, my lord.
Don't worry, I'll take care of it.
Okay,
She
sir.
will say that there is an alternative remedy. Then I'll say that if there is an alternative remedy, so therefore I should give you within 30 days to file an appeal.
Yes, my lord.
Mr. B. Sinha, the learned counsel, appearing on behalf of the petitioner, Ms. U. Das, the learned additional senior government advocate, appears on behalf of the respondent numbers 1, 2,
Three.
3. So and so appears for the respondent number 4 and 5. Full stop. 6 also.
The 6 is the cooperative society, now it is managed by departmental officer.
So 6 also. 6. The present petition has been filed challenging the order dated 28/10/2022 passed by the Superintendent, Food and Civil Supplies and CA Silchar, whereby the petitioner's license, where is that?
License.
Yes, sir, license,
Uh,
my lord.
Whereby the
27.
petitioner's license have been cancelled in terms with section, was cancelled under clause 15(2) of the Assam Public Distribution Articles Order 1982 for the reasons stated therein. Full stop. Ms. Udas, the learned additional senior government advocate, submits that the instant writ petition that this court may not like to exercise its jurisdiction in the instant writ petition, taking into account that the petitioner has an alternative and an efficacious remedy. She further submits that that various disputed questions of facts have also to be ascertained as regards the
Misappropriation of rights.
as regards the illegalities, as regards the as to whether there was any violation by the petitioner to the terms of the license as well as the order of 1982. So Mr. B. Sinha, the learned counsel appearing on behalf of the petitioner, however, submits that the very basis on which the impugned cancellation order was passed is no longer there in view of the
Page 46.
final report being submitted in respect to Kachar PS case number. No, Kachar or Uddarban PS case number 271/2021. Registered under sections 409, 468, 420 of the IPC. First, it is the opinion of this court that these aspects are required to be dealt with by way of dealt with by a forum wherein fact adjudication can be carried out. First, as the counsel for the respondents has submitted that there is an alternative and efficacious remedy. However, it is pertinent to observe that the time permitted under section 29, clause 29 of the order of 1982 is only 30 days from the date of the said order of cancellation. Taking into account that the petitioner herein, if relegated to the appellate authority, to the statutory authorities, has also to be given an opportunity to file the said appeal. Accordingly, this court, therefore, taking into account the subsequent cause of action, that is, submission of the final report dated 18/5/2023, final report, and the acceptance final report in respect to Uddarban's PS case number 271/2000 so and so, and the final report having been submitted, which have been accepted by the court by an order dated 18/5/2023, is of the opinion that the petitioner should be granted an opportunity to avail the remedy of by way of appeal before the appellate authority in terms with section 29, clause 29 of the order of 1982. Accordingly, this court therefore disposes of the instant writ petition with the following observations and directions. Sir. Number one, this court have not dealt with on merits as regards the legality or validity of the impugned order dated 28/10/2021-22, whereby the petitioner's license have been cancelled. Number two, the petitioner herein is granted 30 days from today to file an appeal before the appellate authority in terms with clause 29 of the order of 1982. So it is further observed that if the circumstance that the petitioner files the appeal within the period as within the period as permitted herein above, the appellate authorities shall decide the same on merits and without going into the question of limitation. Writ petition stands disposed. No cost.
The epidemic dispose of some within some time, because a long time has gone.
Mr. B. Sinha, are you burdened with so many briefs that you don't want to come in the meantime with me?
Right.
I'm waiting out here to come with
Right.
another petition, appeal not being disposed of.
Item 5.
Yes, what is this? Oh, the other one. Ah. Yes, why no elections?
My lord, that instructions I will have to seek, my lord.
How many years? 5 years?
5 years. April 2020 was the last time future municipal board had an elected body.
April
Thereafter-
2000?
April 2020.
In between, what happened, my lord?
Ah.
Some of the people of that locality, they challenged the notification which was issued on 28/11/2022. And your lordship decided that at page 58, your lordship will find. Said that the objections were not,
And the objections were made by the deputy commissioner, which was duly considered in the opinion of the city in concern and accordingly finds no ground for a yard dismissed. When did I dismiss?
yes.
On 24/9/2024, these were dismissed.
So there too considerable period of time for my lord litigating this matter.
Anyways, we need to look into it when they are going to do
Yes.
it. Now, I think it is a Silchar Municipal Corporation.
Lordship.
Now, once
The
the
corporation.
corporation comes in, so therefore the corporation has to, the body has to be formed.
Yes, it will have to be elected.
When are you going to form it? That's the
That
only
ballot, yes,
question, because
that
it has
is-
not been there.
Lot
Yes,
of-
there was a challenge. All these things have now been fizzled out. So therefore you have to come up with this. Only instruction when you are coming with it.
My lord, written instruction.
This is election is being done by by the Silchar Municipal Corporation.
Well.
Because it is, they will be doing it. The government has no role out there.
No, my lord, so far holding of election, all that it is up to the government.
Is it?
As well as the election commission,
Of?
Of the state. The state election commission will,
You have a role. So you are the main person. Why is the additional advocate general standing out here? Not in the, you are not there in the podium. You are the main person. You come up with when are you having a fixing a date, because as of now, there is no impediment. Chalo. You should notice making it this year, that next year, which one? This year.
This year. no,
Huh?
election.
Okay. You should notice making it returnable, we keep the first on 5th of January 2026.
Additional. Additional লাগিব। এইটো মই এটা correction আছে, এইটো additional।
Mr. B. Gogoi, the learned additional advocate general, accepts notice on behalf of the respondent number 1,
Three.
2,
My lord, it should be additional
3,
chief secretary, man. May I, my lord, stand?
5,
5.
and 5.
Respondent number 2, it will have to be additional chief secretary. Chief secretary of my lord, Department of Housing, it won't be, my lord. It will have to be corrected. Additional chief secretary, maybe.
issue notice making it returnable on 1, 2, B. Gogoi accepts notice on behalf of respondent number 1, 2, 3,
5.
and 5. Mr. R. Dubey accepts notice on behalf of the respondent number 4, and Mr. Who is your junior to accept notice? So and so accepts notice on behalf of the respondent number
6 and 7.
6 and 7. At the outset, Mr. B. Gogoi, the learned additional advocate general, submitted that the nomenclature of the respondent number 2 has been, the respondent number 2 has been, nomenclature, the respondent number 2 has been wrongly arrayed in as much as it is the additional chief secretary of the government of Assam, Department of Housing and Urban Affairs, Dispur, Guwahati, and not the chief secretary to the government of Assam. Also, Mr. D. Chakraborty, the learned counsel, submits that he may be permitted to make necessary changes. Taking into account the above, this court is of the opinion that the changes can be very well made. Taking into account the above, this court, therefore, substitutes the respondent number 2 as the additional chief secretary to the government of Assam, Department of Housing and Urban Affairs, Dispur, Guwahati 781006. The counsel for the petitioner is directed to file a fresh memo of parties before the registry of this court within 3 days, and the registry shall make necessary correction in the cause title and update the same in the CIS. The case of the petitioners herein, and extra copies to the devotee, extra copies. So, by within 2 days. The case of the petitioner herein is that the Silchar Municipal Corporation, which have been recently created pursuant to the Assam Municipal Corporation Act 2022, does not have an elected body. It is Mr. D. Chakraborty, the learned counsel, appearing on behalf of the petitioner, further submitted that its predecessor, that is the Silchar Municipal Board, have not had a elected body since May 2020. The respondents herein are directed to bring on record their stand by filing the affidavits on or before 19th of December 2025. Full stop. In the said affidavit, the respondent shall also indicate as to what steps have been taken for having an elected body in the Silchar Municipal Corporation, taking into account that it is the mandate of the Constitution in terms with Article 243Q, as well as also the mandate of the Assam Municipal Corporation Act 2022. List accordingly.
Item 6.
My lord, my learned friend is saying secretary instead of.
My lord, so we will make it secretary because respondent 1 is commissioner and secretary.
Additional
It will be
Gusai secretary.
Only secretary.
My lord, tendency, my lord, tendency of the repetition may not be a part of.
Do you think anything is going to happen? Yes, Mr. Bonik.
But so far as the repetition is concerned, husband while working at the bank have dated his last one 27/2025. He was formerly under UBI, but then after the amalgamation, the accounts were maintained by Punjab National.
What is your case?
Well, the amounts lying in the accounts have not been credited to me.
Credit to the savings bank account of Iman, the money lying in the following accounts.
So we have represented to them.
Why do you want all this money?
If the nomination is there, certainly it will follow. But there is one difficulty which would come in, and I must tell, we have also pleaded, that is from the pension amount, an amount of 10,000 was being credited to some person who was allegedly claiming to be the wife, and that continued. She also got. Now there might be a rival claim onto this, which bank needs to take a call. But so far the next of kin certificate is concerned, we have obtained my name and my daughter's name, unmarried daughter's name is there.
Have you made the person,
I do not
party?
know. What I would suggest, my lord, if they give me the details, I would have them included. We would like to go for.
Have you asked the details?
No, no,
Have you asked the
we
details?
have only sought for nomination.
Have you asked the details from them?
So far as the other person is
We
concerned,
dismiss your petition on the ground of non-joinder of necessary.
it would not be necessary party.
No, no, non-joinder, because you see, you have a fight with somebody.
No, no fight.
Yes, somebody is getting some amount.
Yes, she's having, we pleaded that.
So therefore, who is he? What is the account number?
No account now.
Then how is she getting the money?
That part we do not have the.
If you are not clear with your facts, why should we entertain these type of writ petitions?
So my lord,
Or is it something that this court should make a fishing and roving inquiry at your behest?
the amount is lying still, no one has utilized it, is there. Only thing is that.
If there is somebody else. And nomination is, you are just a nominee, you are a trustee, the benefit is to go to the beneficiary, isn't it, Mr.
Yes,
Purvis? Then,
So far as.
and the
nomination-
beneficiaries are not made parties out here. Why should we entertain these type of writ petitions?
But,
Bad case.
we had filed a representation
That
to the
is-
indicating the nominations.
Did you ask who are the persons?
So we'll file it.
Who are the persons who are getting it?
Me, on the pension amount, me, and
Who died?
husband,
Whose husband?
my husband, 28/7/2020.
And how many sons and daughters you have?
One,
Where is he? Not a party?
daughter.
Not a
not
party
a
here?
party. We only stated the next of kin certificate and the nomination as per the bank procedure, whatever they decide, we follow. But only thing is that kindly give us the nomination details so we proceed further. We represented to all the banks.
So you say that there is no nomination in the bank accounts?
There might have been a glitch, but I do not know. That's why we have represented to them.
So therefore, this is a fishing and roving inquiry through this court.
Nothing, we know.
Then what?
What we are praying is that let
You
the
don't
bank-
know anything.
let the bank take a call.
Why should the bank, you go and approach the bank? Is it the case that the bank is not taking a call?
So we have approached the bank.
Where is that?
Why not,
Latest bank account details and nomination status. When did you approach?
why not, the first one would start at page.
When did you send?
That page
There is
19.
no date also.
It's 19.
How do you know? No date, nothing?
No, page 19, we have indicated 6/9/2025.
What is your date?
6/9/2025.
Who wrote
It's sent by
6/9/2025?
Oh, yes, yes. He died.
Then
This is-
6/9/2025.
Yes, there were three registered post documents, you know.
Ah.
All 6/9 to
Then,
the same date, you know.
then all 6/9/2000, have they received it?
My registered post, sir.
Where is the receipt? Where is the receipt?
Page 37.
Huh?
Page 37.
Where is the receipt?
Page 37, the registered. post.
This is the postal receipt that they have received it. Where is it? No case. Go, give it by hand. They are not far away.
No, no, we.
Instead of filing a petition out here, why don't you go and give it by
we
hand?
Stated that we had gone there, but they.
Ah, Mr. Pervez, you, when they give it to you, you look into it.
We'll represent it.
As of not now,
We'll represent.
you withdraw. These type of cases can't be entertained. Yes.
The only
Mi-
thing that they may provide that name so that we come afresh properly. you know. We, only thing which can be sorted out in
Bad
mediation.
case,
I believe in mediation. it was
bad
sorted out.
case.
So withdraw with the liberty.
Heard Mr. S. Bonik, the Learned Counsel appearing on behalf of the petitioner, Mr. A. Pervez, A. Pervez
Yes, my lord.
appears on behalf of the Punjab National Bank. Appears for all the respondents. The petitioner herein, who is the wife of late Bijit Das, have sought for certain account details and nomination status in respect to various accounts of her husband from the respondents. The same having not been provided, the petitioner has approached this court. There's nothing on record that such representation have been served upon the respondents. This court have also taken note of the submission of Mr. A. Pervez that if such requests are made by submitting representations, communications to the respondents, that the respondents would definitely provide the details if permissible under law. So, taking into account the above, Mr. S. Bonik submits that he would not like to further proceed with the writ petition. But on the other hand, the petitioner would be well advised to approach the respondents by submitting due communications by hand.
So withdraw the liberty, if I need back.
What liberty? I gave you this, no? That is enough. He is going to give it. I will allow your prayer also. What additional things you want?
Like-
Isn't it submitted that he is going to give it to you? It is, however, observed that in the circumstance such details are not provided, it shall be, the petitioner would be at liberty to approach.
Contract is of the period 2014. The approach road was not good. So they made the road only on the year 2014, 24. So page 227, your lordship again, you see. They're asking that you complete the work now.
What do you want? Money?
Money 30 lakhs, they are required
On
to
the
pay.
final
and they have
lap,
completed page
as on the
28.
taking over the site from the people, and why the balance?
I can complete the work provided they give me the present rate, not at the rate at the, in the year 2014.
You were given a contract for construction of the branch of Assam Government Press at Titapur.
Here,
You completed it.
only 27% of the work was completed in the year 2017. And thereafter, my lord, there was no approach road. So government has undertaken to complete the work by 226, page 226, the year 2018,
226.
They've undertaken to complete the work in the year 2026. Yes.
Construction director, so with reference of the owner to you, the item of the works related to approach road was not incorporated in the original, and as such the approach work has been delayed.
Document was
However, the
completed in the year
estimate of the approach has
2020.
already been submitted, but the sanction for the same is awaited till date. Whether it is stated that the amount of rupee has been released till date and the phase-wise requirement of the fund is required in the end.
Page
Then-
227, your lordship. 227. They're saying that the road is completed,
Failed
for
to-
contractor complete the work. I have submitted a reply that at the rate of 2014, it is not possible to complete. Plus account has been closed. And
Then,
I have given a reply at page 228.
what do you want? That you are not willing to do it at that rate.
At that rate, and plus the 30 lakhs rupees is due, they have admitted that 30 lakhs is due, and they have to pay me the amount, otherwise you take back the, they have to take the project in their hand. Government is to take, if they cannot,
So the contract was for how long?
contract was for 1 year, but it was extended from time to time.
Where is the extension?
That extension order, Manoj, I could.
So
not-
without the contract categorically stipulates that there is a requirement of a written extension.
It admitted by them, my lord, the approach road was bad, and it completely broke down. And
No,
I
no,
have
but whatever may be, if there is an extension, there are two forms of extensions.
Yeah.
One is for your fault and one is for the fault of the department.
Well, yes,
Now, the fact is, if it is fault of the department, then it is a case by which you can very well claim some damages.
Yes.
But as regards the fault of your fault, you cannot.
I cannot, my lord,
Now, the question is whether they are in a position, whether these aspects can be decided by this court.
well, in view of the at page 227, it says, my lord, you complete the work now because the approach road is completed. It shows that my contract is alive. So therefore, my lord, I filed a reply saying that, my lord, at the rate of 2014, I cannot complete. If you enhance the rate, I can complete it.
So isn't it there, therefore they are
They
saying
are
that
to-
whether they would like to terminate it, whatever may be, there
So
might be
whatever-
various terms and conditions.
At
Isn't
this
it,
stage-
Mr. B. Gogoi?
The alternative remedy is there, otherwise melody in the contract itself. Page 174,
Eh?
page 74 of the writ petition. Cause my lord 24, 25.
So, go there.
My lord,
One of the judges will be your judges.
my lord, what I'm saying, the dispute has not arisen at all. At this stage, subject to what your lordship. means.
If there is no dispute, then why are we adjudicating it?
227, my lord, that letter is there, and in support, in response to that, I have given a reply. And if they dispute, my lord, then only I can go to avail these provisions of 24 and 25. I've given a reply, my lord. If they say no, yeah, I cannot give you the money, I cannot enhance the rate also. And your lordship will kindly see that page.
They write you a letter in the
Yes.
year 2024,
Yes,
11/9/2024.
yes.
You exactly after 1 year wake up and write a letter on 10/9/2025 and say that there is no dispute.
Several occasions.
Where is the several? There is no several business out
Can you
there.
say page 231 also?
No,
Page 231.
bad case. No case. Not a case for
Page
entertaining.
231, page 232.
What is this? This happened this happened prior to that, construction submission of bill to the chief engineer by the executive engineer. This executive engineer keeps on doing all these things.
So I pray, my lord, let them say whatever they are required to say. If they say in negative, my lord,
I can do one thing in your case. I can issue a notice. No, at best, as you are insisting, a notice without date fixed,
Without day fix.
without fixing a date.
Lord, we have a big
Issue
hole in our
notice
system.
making it returnable by 6 weeks. When they file or not file, this is, you are not entitled to a motion or, otherwise it's a case for dismissal.
I think, my lord, if this is.
No, because of the fact, Mr. Das, the reason why I'm saying so. First, it is a dispute which can be very well adjudicated by the dispute board. And I would have understood that if the dispute board is some one-sided by these people only, it's not. One person will be from them, one person will be from yours, and both of your persons will appoint somebody. So there's nothing of any unfairness or biasness or leaning towards them. So this is the question as to whether they are, because you are asking them that kindly pay me this 30 lakh and I am not willing to do. Now there are various terms and conditions by which it is to be regulated. Whether there was an extension, whether you are entitled to damages, these are various aspects which can be done before those authorities. Why should this court entertain this type of dispute?
So what your lordship may say, my lord, in view of my letter, if they respond in negative, my lord, a dispute will arise. Otherwise, my lord, I leave it to your lordship, my lord, I have no option. But I think, my lord, according to me, my lord, your lordship will kindly appreciate that the letter given by me, that 2014 date, because I have done some portion of the work, 27% of. They are also probably, they might say, all right, we are going to enhance the rate, or we are not going to enhance the rate. They have not responded to it. If they respond, therefore I'm playing.
Have you gone for a fresh NIT? No.
No,
That,
they have
well,
not-
no statement is there.
there's no fresh NIT. I'm sitting at bar. Government is also. my
But,
lord,
but
I
if
can
it
change
is,
class.
if it is a dispute, you want what? That they should only reply. That's all.
They will reply. If they say it in
You give
negative.
a reply within 7 days. We have it, you give a reply rejecting his, then we send him to the dispute hearing.
7 days, let them reply. Because if they're in negative, they will take some time because they will have to take concurrence from the higher authority. Account is also closed, my lord. Account closed in the year 2017 and the completion certificate is there at the last time.
No, there are many permutations and combinations which will happen out here, taking into account that whether it was permissible to
Yes,
do
you
so,
know.
whether they wanted the extension, all these factors, because you approach,
Yes, yes.
why on earth after 1 year you approach?
No, several, because on several occasions they have gone there. They said that you wait for some time, we are going to give you some enhancement. That is verbally, but I do not have any records to say. But this is what happens with them. They are also interested to complete the work.
Okay. Issue notice making it returnable on 1st of December 3rd of December 2025. Mr. B. Gogoi, the learned standing counsel.
No, I appear as additional legal for all the respondents.
The learned additional advocate general accepts notice on behalf of all the respondents. Full stop. The petitioner herein has approached this court. Extra copies be provided during the course of the day. The petitioner herein has approached this court seeking a direction that the respondents should make payment of the amount of rupees 30,47,061 to which the petitioner is entitled to, as per the admission made by the respondents in the various communications. In addition to that, the learned counsel appearing, senior counsel appearing on behalf of the petitioner further submitted that the petitioner was granted a contract for construction of the Assam Government Press at Titawar on account of non-availability of the approach road, which is also an admitted fact. The construction could only be completed to the extent of 27%. Subsequently, in the year on 11/9/2024, the petitioner was asked to complete the work on the ground that the approach road and all-weather approach road have already been constructed. The record further reveals that after 1 year, on 10/9/2025, the petitioner wrote a letter to the respondent asking them to pay the amount of rupees 30 lakhs 47,061 and further to enhance the rates at which the petitioner was allotted the contract. Mr. B. Gogoi, the learned additional advocate general, has drawn the attention of this court that these aspects ought to be dealt with in terms with the contractual conditions, more particularly clauses 24, 25 of the general conditions of the contract. And as such, this court may not entertain the instant writ petition. Mr. Bidas, the learned senior counsel, submits that on 11/9/2025, the petitioner had written a communication, but the respondents have not responded. And as such, there is no dispute for the petitioner to go in terms with section 24 and 25, clause 24 and 25 of the GCC. Mr. B. Gogoi, the learned additional advocate general, shall apprise this court on the next date as to what steps have been taken by the respondents in pursuance to the communication dated 11/9/2025 submitted by the petitioner. List accordingly.
Estimate.
This case, Your Lordship, challenging the violation of section 124 of the Customs Act, where notices are mandatory while seizure of a vehicle under section 110 of the Customs Act. In this case, Your Lordship, there is a period of 6 months, but within that period, they have never never issued any notice to me. And after now, about 1 year has passed. No notice, and if they have extended that, then also a notice with a specific order has to be passed. That has also not been done. We made an application also, that has not also been, we made an application that has also not been considered by them, and has no order has been passed on that.
You made an application before whom?
Before the Commissioner of Customs, Deputy Commissioner of Customs, that is at least,
Deputy Commissioner of Customs Department.
yes.
Is there something such department?
Yes, Your Lordship.
Deputy Commissioner, Customs Department.
Yes, Your
Deputy
Lordship.
Commissioner of
Deputy
Customs.
Commissioner,
What have you
Customs
done with this
Department.
application?
Pardon, Your Lordship.
What have you done to this application?
Lordship will have to obtain instructions on the same, Your Lordship.
Okay, we have it day after.
Yes,
10 instructions, what is there?
yes, Your Lordship.
Issue notice, making it returnable on
Item 8.
28/11/2025. Miss so-and-so. Miss A. Gayan accepts notice on behalf of the respondent number 1. Miss
But-
so-and-so
Yes, Your
accepts notice on behalf of the respondent number 2, 3,
4 and 5.
and 4.
5 also.
5 is also there, 5.
Yes, Your Lordship.
Good stuff. The petitioner herein is aggrieved by the seizure of its 10-wheel Tata 10-wheeler container truck bearing registration number RJ14GJ3577, bearing chassis number and engine number. You find it at paragraph number 2. Put that. So the petitioner had also submitted an application before the respondent number 4. However, no steps in that regard have been taken. It is under such circumstances the petitioner is before this court. The respondents, number 2, 2, 3, 4, and 5, shall apprise this court on the next date as to what steps have been taken by the respondent number 4 upon the application so filed by the petitioner.
Sure.
Friday.
Yes, Your Lordship.
We take the steps today.
Okay, I'll do.
Supplementary item 47.
Obliged.
Yes, Miss A. Gayan, what is wrong with your central government? You don't appear. This is not, I've seen in many matters the central government is not represented.
Yes, my lord.
Should we ask the law ministry to have competent people?
No,
Because of the fact that in many matters there was nobody there. Isn't it, Mr. Chaudhary?
My lord.
That day also one matter that these central government councils are nowhere to be seen.
Yes, my lord.
And you see, we don't like the personal appearance of those officials.
My lord.
If you want then we'll put it that the central government, the councils are not doing their thing and we are doing.
My lord,
Be careful
yes, my
with
lord,
this.
but today is fixed the meeting for all the central government council at 1 PM regarding this issue, my lord, RK Dev Sodri, my lord. We will take it the issue
Yes, I have
seriously,
to
my
tell
lord.
him.
Yes,
I
my
had
lord.
to tell him this thing that this is happening.
ma'am.
Because of yesterday there was one matter, some central provident fund. I heard the matter with Mr. B.
Yes.
Pathak, but none of from the central government was appearing. And resultantly, the matter could not be disposed.
Yes, ma'am. That's
Very
why, my lord.
difficult.
That's why, my lord.
Be careful.
Yes, my lord.
Yes, Mr. J.M.A. Chaudhary, what is this?
My lord, I am only for non-compliance of section 15(2) of the Assam Public Distribution Order, my lord.
No notice.
No notice, no shock.
You have been
From my lord 27/2024.
terminated,
No,
cancelled.
License suspended, thereafter no shock was nothing.
How long?
Till date, my lord.
From?
From 27/2024. More than a year, my lord.
I'll take instruction notes.
And my lord 15.
1 week.
1 week, Lord. Next week.
My lord 15(2) specific, my lord, they cannot continue with the suspension.
1 week.
Yes.
One week.
Yes.
Issue notice, making it returnable on 3rd of December 2025. Mr. S.R. Bolwa accepts notice on behalf of the respondent numbers 1 to 6. Extra copies of the writ petition be served upon them. Oh, you are there. Cooperative. 1, 2, and 3. And he appear 1, 3, and 4, and you appear for 5 and 6. 5 and 6, huh? Take their names. Extra copies of the writ petition be served upon them.
No, 6 I am appearing.
5 area 6, huh? The copies of the writ petition be served upon them during the course of the day. The petitioner herein is aggrieved by where's the suspension?
Page 15, my lord. Type copy and my lord 15A will be the my lord 14.
Is aggrieved by the continuation of the order of suspension dated 27/2024 for a period exceeding 90 days. And as such, the present writ petition, Mr. S.R. Bolwa, the learned counsel appearing on behalf of the respondent shall apprise this court as to what steps have been taken in taking terms with clause 15(2) of the Assam Public Distribution Order 1982 on the next date without fail.
48.
Obliged.
Obliged.
Yes, Your Lordship, I'm appearing in this case.
Yes.
Your Lordship, this is a petition pertaining to the fact that the bid submitted by the petitioner has been rejected technically, and he has been declared to be non-responsive. Before I take Your Lordship to the grounds, I'll merely refer to the sum of the facts in the present case. The NIT is issued by respondent 4. Your Lordship can have a look at annexure 6, page 56. This is for the purpose of construction of a bridge. This is, my lord, page 56, annexure 6.
Who has issued the NIT?
Respondent number 4, Your Lordship. This is Chief Engineer, Project Udyak Duma.
What does that mean? Your technical bid has been cancelled?
Yes, my lord. They have rejected me technically. And
Why?
the ground is that I had not submitted my EMD. Initial ground was this. Your Lordship can have a condition at page 57. Condition number 11. Earnest money to the extent of 15 lakhs was to be deposited, but it was exempted in case of those who were enlisted contractors and those who were entitled to the benefit of MSME registration in terms of the rules they have referred to.
You required for other contractors attached. Can
Yes, sir.
the technical bid for no.
They,
You are an MSME.
I am an MSME and a small enterprise, and I am an enlisted contractor also. Initially, they rejected my bid. Your Lordship can have a look at page 197.
Yes. What is
They
your
rejected.
name? SGF Infra Private Limited.
Yes, Lord. Your Lordship may have a look at, my Lord, my bid is rejected on the ground. Your Lordship will have at page 200.
Recommendation. Bidders recommended for participation in.
Yes, sir.
And so bidders not recommended.
Yes, my Lord. My name, my Lord, figures at serial number 6.
EMD exemption limitation is 11 lakh only as the firm enlisted with BRO so and so in his tender EMD so for Iman. The firm has not submitted the additional security amount.
This is, my Lord, I'll explain what they meant by this. I am an enlisted contractor with the respondents. At the time of my enlistment,
So you are a valid enlisted AR.
yes, my Lord.
A contractor with the BRO.
Yes, my Lord.
And you have already submitted standing security deposit.
Yes, my Lord. Yes, my Lord.
Where do I find that?
It is the admission on their part. They here, Your Lordship may have at this page itself. They say that bid, same page, Your Lordship are just reading, same page. What they were trying to convey, they were trying to convey that you're an enlisted contractor. You have given the security to the
index number so and so.
You have given the security to the extent of 11 lakhs.
Only as the firm enlisted with BRO so and so.
They say in this case, EMD required was 15 lakhs. You are an enlisted contractor. You have given the security of 11 lakhs. So we are rejecting you. Thereafter, I responded to them. I said this cannot be a ground. Even otherwise also, I am an MSME. Then Your Lordship may kindly say they initiate.
Mr.
Yes.
I've got.
Yes, ma'am.
Yes, Mr. H. Gupta.
My lord, the page numbers are not tallying with my page numbers. But there is a.
Okay, take a copy from him.
Yes.
He will tell you with everything.
That.
You don't need so many pages, but
My
the
lord.
page is, there are 2 pages. One is page 57.
My lord.
Wherein it says that the earnest money is not required to be attached with the tender by the valid enlisted contractor.
Yes, ma'am.
With BRO who had submitted standing security deposit.
Ma'am.
Isn't it?
Yes, my lord.
and MSME registered firms as per so and so. But it is required for other contractors to be attached scan copy with the technical bid for 15 lakhs in the same of call the receipts, term deposit receipts, special term receipts in favor of the chief engineer so and so obtained from any nationalized bank. Now, here you don't say that anybody having a standing security deposit of 15 lakhs. Is it mentioned in your term?
That is not mentioned. my lord.
So if it is not mentioned, isn't it therefore a requirement that if you something you wanted 15 lakhs to give him an opportunity? I'm asking you
Yes,
that he could have very well given the 4 lakhs if necessary.
that is true.
Instead of cancelling it, this appears to be very high-handedness in view of the recent, another judgment, a recent judgment of the Supreme Court. That day I gave it to Mr. Chaudhary. I gave one judgment in that SPS. Yes, I gave you one judgment of Justice Surya Kant, wherein a new tender, anything new has been brought in, then you have to give him an opportunity. If you don't give him an opportunity, it will violate the principles of natural justice. I gave you one judgment. There's a judgment of 26th of September. It's a judgment. So,
Well, there is something more. There is something more.
yes.
After they reject me on this ground, I bring it to their notice that I had already applied as a MSME also.
SCC online 1942.
2025
SCC online.
SCC
1942.
online SC 1942, na?
Yes.
Okay.
Honorable Chief Justice presently, earlier Justice Suryakant and Justice Joy Malla Bakshi.
Yes.
Your Lordship,
Yes. Another thing
after
is
they,
what?
another thing was, I brought it to their notice that number one, you have not said that enlisted contractor should have the security of 15 lakhs. Secondly, I am a small enterprise registered as a MSME. Your Lordship, then they reinitiate the process. Process is reinitiated by them. Your Lordship may kindly see my communication to them, which I had given to them. I had placed before them the everything, including this communication. Have a look at Annexure 10. This is my letter dated 12th September 2025 to them. 12th September 2025. I bring it to them that I am already registered as a MSME.
But you are medium enterprise.
No. I had already been a small enterprise. Your Lordship can have a look at page 223, Annexure 13.
223.
This is, my lord, 219 with your lordships. 219. Annexure 13. The lordship, may they admit. I'll read, my lord. Refer you letter number so and so. In this connection, it is intimated that as per Government of India Gazette notification as so and so, and the verification of your MSME and Udyam registration portal, your certificate is showing as small enterprise.
You must update your registration details in
Yes.
income tax GST on the Udyam portal at the end.
Here they, my lord, commit again mistake.
It is done online on the official. Failure to
Here-
update your details can lead to the loss of access to benefits under so and so.
Here they again commit a mistake. Now what they do, your lordship can have a look at the clarification issued by the MSME. That is available with your lordship, my lord, at page 230. What they are demanding from me is my this CA signed GST filing return and income tax return for the financial year 2024-25, which is not at all required. Your lordship can have a look at this, my lord, page 230. Page 230. This is clarification by the ministry. Is it before your lordship?
No, Mr. What's your
Yes, your
name?
lordship.
Mr. Pant.
Rahul Pant, sir. Rahul Pant.
Mr. Pant.
Yes, your lordship.
The thing is like this, in view of you are being taken up at a stage when there has been a notification in the month of April 2025,
Yes, my lord.
whereby the values of all these small, medium, micro, small, and medium enterprises have been increased.
Yes, your lordship.
Just for example, I think if micro is now 10 lakh, 10 crores.
Yes, my lord.
Yes. So the small would be 100 or 50 or something like that. So that is
Yes,
another
yes, yes,
notification which
yes,
has come.
absolutely right, your lordship.
Yeah.
Now, my lord, with the change in this criteria, this financial criteria, the small is investment does not exceed does not exceed 10 crore and turnover does not exceed 100 crore. Earlier it was 25 crore investment, 25 crore.
Earlier it was 5.
Earlier it was 10 for small.
No, earlier it was 5 for micro.
Yes, my lord.
Micro it was 5.
Yes,
So
my lord.
they
I am a
increased
small.
it.
I am small. No,
Anyway,
this
now it has become 10.
it has become 10. Now for small, earlier it was 10.
The
Now it has become 20.
when the tender was issued, it is now
Yes,
10.
it is 10. 10 crore
Tender
investment,
issued
100 crore, my lord, is the
tender was
turnover.
issued in the month of, what is the date
June
of
2025. And I am small since 1st April 2025.
What is the date of the heart? On 23rd of June 2025,
Yes,
it
your
was
lord.
now 10 crores.
Yes, my lord.
And for
And
small, it is 100.
100 crore. So I am from 1st of April 2025, I am small. That certificate I have given. No, they wanted to have the hard copy from me. And latest financial return criteria is totally different. I brought to your lordship notice. Your lordship may kindly see what is the criteria. They have completely misunderstood this criteria. Your lordship can have a look at page 234, 230, page 230.
230?
Yes, your lordship. This is clarification which has been issued by the ministry. Number one, I am not supposed to now file any of my returns or my GST return. It is auto-fetched. Your lordship may kindly have a look at clause 3.
So you have either the option to do it, either it
Annually.
would be done through self-declaration or by
Yes.
income tax. And if it is
Income.
done by the income tax, that would be given precedence from the self-declaration.
Yes, your lordship. Now your lordship may kindly see which return is to be taken into account. Next, serial number 5. For by declaration for 2020-21, the relevant return is of 2018-19.
So, Mr. I think the thing, what they try to say is that, if I am not wrong, that the filling up of the details shall be first it may be fetched from the IT department
Yes, my lord.
as well as from self-declaration.
Yes, your lord.
IT department concerned would be given precedence
Yes,
and taking into account that for 2018 and 19, the
Yes, my lord.
filing of the return would be not normally July 2019.
Yes, my lord.
And it may further be extended if it is a case of audited so and so.
Yes.
And therefore they kept the period as 2020-21. But in the meantime, if you have
Yes, ma'am.
already filed your return, it would be fetched from the income tax department.
Automatically.
Automatically.
Yes, yes, your lord.
So you
No.
mean to say, therefore, that not submitting a self-declaration would not therefore amount to any infraction on your part?
Absolutely. Absolutely. Now, your lordship, may kindly turn to page 236, which is my classification certificate which has been given. Your lordship, may kindly see 236, which I had given to them. Your lordship, may kindly see for the period 2025-26, I have been classified as a small because of the change in the criteria which was statutorily changed by the respondents. And my GST return, my income tax return is now auto-fetched by the this Udyam registration portal. Because my lord, Udyam registration is linked with my PAN card and my GST number. So automatically, whenever it is filed, it goes to them. Once I have been granted the registration certificate as classification with effect from 1st of April 2025.
And if I'm not wrong, by amendment to section 8, which was brought in, this Udyam registration certificate,
Yes.
and more particularly in view of some notification in the year of June 2020,
Yes,
which resulted in this Udyam registration certificate through other Aadhaar identification.
Yes, my lord.
So therefore, these are required. This would hold field than any other document.
Yes, your lordship. And certificate which is uploaded on the website is the only proof of my registration, which they admit in their communication when they sought the information from me.
Now, did
Your
you
lordship
submit
can
this Udyam registration certificate?
absolutely,
before
sir.
the-
Absolutely, absolutely.
with your
I have
bid?
submitted this. Yes, 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 yes. I have given my registration with the bid also.
My lord, no, they have not submitted. At the time of submitting the bid, my lord, they are seeking exemption or not, my lord, as per my instruction. I'm confirming, my lord, because at the time when they make the bid, they should make the intention clear that they are seeking exemption on account of, my lord, either
Upload किया था.
in enlisted contractor or, my lord, MSME. So far as the second issue, my lord, MSME is concerned, admittedly they were small, my lord. To that we are not disputing. But the requirement of earnest money of 15 lakhs, my lord, that is a mandatory condition.
No, mandatory is depending on this. As per that particular clause, you say
Yes.
that if a person who is enlisted with the bro
My lord.
and having deposited some security,
Yes.
he need not submit the 15 lakhs EMD. As well as those coming under the MSME in terms with the GFR 170. And he further say that in respect to the others, this is also very vital. Others, they have to bring a scan copy of the EMD taken out with having a validity of 90 days.
My lord.
A scan copy, so you don't even require the original. So therefore, the question is, the clause in the tender is very clear that you can very well ask this. And if he's enlisted with a bro and had some security deposit, you cannot, unless you make it very clear that it has to be 15 lakhs.
That is there, my lord.
Now, the second is, if they have not submitted the MSME certificate, obviously, they are not claiming under that,
My lord.
but they are claiming as per the bro. Now, the
Yes.
question is whether they have claimed as per the MSME or not. That will be subject from the records.
Yes, yes, my lord.
And when was the rejection? What is the status now?
No, second rejection, your lordship, may kindly see.
Huh?
Second rejection. They considered my MSME. It is not that they did not consider. Now, see, kindly see the what are the grounds of rejection.
No,
Kindly have
Mr. No, I'm asking you whether
Yes.
you have submitted the MSME certificate at the time
Absolutely,
when.
sir. We had submitted. We had submitted. This they have also verified. Kindly have a look at page 34 and Annexure 1. This is second rejection. After I brought it to their notice that I am MSME, I had submitted my bid as a MSME also. Then this is second rejection at page 34.
Page 34. what is
34,
that?
sir, Annexure 1. And your lordship will find the grounds of my rejection at page 38. Serial number
Page
6.
38, non-submission of the proof for uploading of updation on MSME registration server.
Yes, this is what the ground has been taken. And second ground is due to non-producing hard copy MSME certificate or small registration, small category.
Huh?
First is due to non-producing
Non-producing
hard copy MSME certificate of small category. Second is non-submission of proof or uploading of the updatation of MSME registration authority, hence disqualified. Both are, my lord, absolutely absurd grounds for the simple reason MSME hard copies are not issued, they are downloaded from the site. It has a QR code also. And they admitted in their communication that we have verified from the website of
No, but
the
Mr. Pan, the question is, did you apply as an MSME?
Yes, absolutely.
Well, how do we can only find out that only from the records?
My lord.
Here comes MSME.
But
Really?
my lord, one condition they have not complied. That is, my lord, if my lord takes the page 72. My lord, the
Yeah.
first condition, that clause number 11, earnest money, my lord. It says earnest money is not required to be attached with tender by the valid enlisted contractor with the BRO who have submitted standing security deposit and MSME registered firm as per rule 171 of GFR 2017. Now, my lord, clause B, unlisted contractors and enlisted contractors with the BRO who have not submitted standing security deposit will submit the tender accompanied with the earnest money amounting to 15 lakhs.
Yes, there's no quarrel with that.
There is the requirement, my lord.
No, but the fact that they had,
My lord.
they
They
had a security deposit is
to
not in doubt.
My lord.
It is 11 lakhs.
Yes.
Now the question is, you have not mentioned in your tender that it should be 15 lakhs.
My lord, this clause B implies that, my lord, remaining 4 lakhs have to be given.
No, where is it? Read for if it is less, then the
My lord,
remaining
it
has to
says,
be
my
paid.
lord, unlisted contractors and enlisted contractors. Enlisted contractors.
Who have not submitted standing security deposit
Yes.
will submit the tender. So what is this standing security deposit?
Standing security.
As per him,
Eleven
there's no denial of the fact that he had a standing security deposit of 11 lakhs.
And they knew that the remaining, there is a shortfall of 4 lakhs.
No,
So, my lord,
unless you say somewhere in the tender that it is a shortfall, that standing security deposit means 15 lakhs. Somewhere it has to be shown, na?
my lord.
If it is not shown, then how do you reject on that ground? But this is not the ground now for rejection.
My lord, that second ground is after the representation. The main ground remains the same, my lord. On the ground of non-submission of the EMD.
Of?
Non-submission of the earnest money deposit.
So
of 15
therefore,
lakhs.
what is this at page 34?
That is, my lord, on their representation, my lord, they.
No, page 34 is for everybody again.
No, they had reopened the entire issue.
2025. Huh?
No.
We do one thing. This simply, have you opened the financial bid? No, na?
They have opened, sir.
No, financial
They
bid
have
is-
opened the financial bid.
but we have
They
not
have opened the financial bid, and I have placed on record the financial bid summary also. Your lordship can have it at Annexure 2. And my lord, this page, your lordship may have a look at 42. 42. हमारी bid कितनी थी?
Yeah.
Yes, your lordship may kindly see, my lord, the bidder who has been declared L1, his bid is, my lord, 19 crore 20 lakhs.
Hmm.
And my bid was 85 lakhs lesser than him. But since I am technically rejected, they did not open my bid.
That bit becomes, yeah, but this was open when?
This was opened 1 minute after, my lord, this declaration of this technical evaluation. On the same day.
So it was open on 8th.
On the same day, they opened the technical, they uploaded this technical information, they opened the financial bid.
And you have approached this court very late.
We were trying to, my lord, figure out how to go about
You have
it. And
approached on 22/11.
yes, your lordship. As per my information, my lord, in case the contract has not been signed by the respondents with the this private respondent, then, my lord, it can be put on hold. But this is absolutely, my lord, arbitrary rejection of the petitioner.
But you should have approached. You know that the question is about the tender.
Yes, I appreciate, my lord, your
The
lordship's
Supreme,
concern.
Court have passed various orders by which it says the scope of judicial review is limited.
Yes,
and it
absolutely.
Is limited, and then also approaching so late. You have a good case, but the
So once your lordship, my lord, in case your lordship are convinced that it is palpably wrong what they have done, then I think, my lord, your lordship have the discretion to intervene into the matter, because
palpably
it is
wrong
also
is another thing. But should this court now indulge into this thing when you have come before this court so late? That is the
till date,
only
my
issue.
lord, there is no
You have
commencement
a
of the
case.
work.
There's no quarrel
Yeah.
with that. You have a case. On the more particularly on the point of the EMD, they should not
Yes,
have
my lord.
rejected it. But the fact that you have come late, but it would be prudent. But anyways, I think where are the other parties?
Yes, my lord. They are parties. All are the, my lord, the officials except, my lord, the L1 bidder, who I have pleaded as respondent number 11.
But if they don't give it to L1, they give it to L2.
L2, my lord, is still higher.
It is not that the highest bidder only will get it.
Absolutely, but once they find us technically qualified, then there has to be some reason to deny it to the L1.
If they could have such reasons to deny you, wouldn't they have reasons for denying the highest bidder also?
But this is the, I
Anyway,
think that's
you do it at your risk,
There are
not making the other person a party.
There are other bidders also not on the same ground it was rejected.
No, anyways, so but they have
EMD
not approached this court.
No.
I'm not passing a stay here. There's no worry, but we like to dispose it of as early as
No.
possible. Okay, we have it before vacation. We finish it off.
Your lordship, may
notice-
kindly see, my lord, in case with your lordship's permission, in case, my lord, contract agreement has not been signed, then your lordship, my lord, subject to that condition, your lordship can put and hold the signing of the agreement.
Then I will also apply paragraph 27 of Ronak.
That is
submitted
absolutely,
indemnity to the
your lordship, may
loss. Because you see, the question is then it's a question of loss. You give an indemnity that you are going to
I am ready to do
indemnify
that.
in the circumstance you lose the case.
I am ready to do that.
Okay.
I'll do that.
They are ready to do so. So they'll let them. So that will be only operational from the day they have given that indemnify. If you don't give that indemnification by tomorrow, it won't be effective. Okay.
Oblige.
Issue notice, making it returnable on. Then we don't need to hear it so early. As you are giving an
We are also not, sir, interested to delay the matter. Sooner it is disposed of, better it is for
but the
us
court
also.
Mr. Pant, has other matters. We are nearing the vacation.
Absolutely, I can understand your lordship, my lord.
In the month
But
of
I think that, my lord,
you have it in the
in-
month of February. They just stay operating.
your
And
lordship
you
may
will
kindly,
indemnify if you
we will
lose it.
not have any objection to disposal of the case at admission stage itself at the earliest possible opportunity, because whatever facts we have placed on record are the facts. Other party, this official
No, the only
respondent,
question is,
have to
Mr.
only-
Counsel, you have
Yes,
approached this court late.
maybe to that extent your lordship are right. I have no quarrel
you
with that.
see, one day late 2 day late is a different aspect, but if
But
there
your
is
lordship can
if
see,
it
my
is
lord,
late out there,
you-
it becomes a very difficult proposition for this court. Why
Your
have you
lordship may-
filed on 22nd? You knew it.
they,
You
my lord,
knew it very well that this could have been filed. You knew it on 8th. They have opened it. Anyways, take the order. Issue notice making it returnable on 16th of December 2025 at 2 p.m. Full stop. Mr. H. Gupta accepts notice on behalf of the respondent numbers 1 to 10. Extra copies of the writ petition be served upon him during the course of the day. As regards the respondent number 11, the petitioner is directed to take steps by way of speed post during the course of the day. In addition to that, the petitioner is also directed to effect service upon the respondent number 11 by way of dusty routed through the registry of this court and file an affidavit of service. Full stop. The said service be effected upon the respondent number 11 by 1st of December 2025. Full stop. The case of the petitioner herein is that a notice inviting tender was issued for work inviting bidders for design and construction of 120-meter span steel superstructure, bracket thorough type, bracket close, major PM completed in all respects over T Pani, Roman 3, Nala at kilometer 32, 2000, 32,2000 on road Hayuliang, Metaliang, Sagol, এইটো লিখি দিব এতিয়া full stop. ইয়াত paragraph 2 আছে full stop. The petitioner participated in the said bid along with various other bidders. Full stop. The petitioner's bid was held to be technically not responsive. By a communication date, by an order dated, where's the first order?
it's your lordship at page 197. It is 8th of September 2025.
By an order by the evaluation carried out on 31st of July 2025 on the ground that the petitioner that the EMD exemption limitation is rupees 11 lakhs only as the firm enlisted with BRO wide index number S-68 at HQ DGBR. It was also mentioned that in the tender, EMD sought for 15 lakhs and the firm had not submitted the additional security amount against the EMD for which the petitioner firm was disqualified. The learned senior counsel appearing on behalf of the petitioner has referred to clause 11 of the notice inviting tender and submitted that the earnest money is not required to be attached with the tender by the valid enlisted contractor with BRO who have submitted standing security deposit and MSME registered firms as per rule 170 bracket Roman 1 of GFR 2017. He submitted that as the petitioner in question was a valid enlisted contractor with BRO and had also a standing security deposit, and apart from that, a MSME registered firm, the petitioner was entitled to EMD exemption. Full stop. The learned senior counsel submitted that the rejection so carried out on 31/7/2025 was brought to the notice of the respondent authorities. Full stop. It is seen that the respondent authorities duly accepted the same. But however, have taken up another ground that the petitioner firm was a medium enterprise and as such not entitled to the benefit in terms of Rule 170 Roman 1 of the GFR 2017. the learned senior counsel submitted that this ground which is now being taken, which was been taken in the minutes of the meeting held in the evaluation, technical evaluation carried out on 7/11/2025, is a fresh ground being taken, and without taking cognizance of the fact that the petitioner is a small enterprise as per the Udyam certificate, registration certificate issued by the Ministry of MSME. He therefore submitted that the respondent authorities, for reasons best known, have adopted a stand to reject the petitioner. And as such, they impugn. And as such, the action on the part of the respondent authorities are not fair and transparent, which violates the mandate of Article 14 of the Constitution. Per contra, Mr. H. Gupta, the learned counsel submitted that the petitioner herein did not submit the MSME certificate at the time of submission of the bid. In addition to that, the petitioner had also not applied as an MSME, which is a requirement for taking the benefit in terms of its Rule 170, Roman 1 of the GFR 2017. Be it as it may, this court have duly heard the learned counsels appearing on behalf of the parties on the question of issuance of interim directions. It has been brought to the notice of this court that in pursuance to the evaluation, technical evaluation carried out on 7/11/2025, the financial bid was opened on the same day or the next date. And the respondent number 11 has been found to be the L1 bidder. The learned counsel, senior counsel appearing on behalf of the petitioner submitted that as on date, there is no agreement entered into by and between the respondent number 11 with the respondent authorities. And as such, till the next date, the said may be stalled. Full stop. This court has given an anxious consideration and do not file an answer to the aspect that on 31/7/2025, from the respondents, answer from the respondents on the aspect that on 31/7/2025, the respondents have rejected the petitioner on some other ground. However, the said ground was duly satisfied. And later on 7/11/2025, the petitioner has been rejected on another ground. This court have duly taken note of clause 11 of the notice of tender. And a perusal thereof reveals that in order to get, prima facie reveals that in order to get the benefit under the earnest money deposit, exemption from the earnest money deposit, the tenderer in question has to be a valid enlisted contractor with BRO who have submitted standing security as well as MSME registered firm. As it is the stand of the respondent authorities that the petitioner did not claim itself to be an MSME registered firm at the time of submission of the bid. Unless the records are placed before this court, it is not, it cannot be ascertained as to whether the petitioner had submitted the bid in terms of as an MSME registered firm. Taking into account the above, this court is not inclined to grant any interim directions at this stage. Which shall be considered on the next date, when the records are made available by the respondents in respect to the bids submitted by the petitioner, in respect to the tender in question. Be that as it may, it is observed that if any agreement is entered into by the respondent number 11 with the respondent authorities during the pendency of the instant writ petition, the same shall be subject to the outcome of the writ petition. And merely because of the fact that this court had not granted any interim directions today, the same shall not create any equitable interest in favor of the respondent number 11.
I'm highly obliged, Your Lordship. For the patient hearing, Your Lordship had granted me.
Mr. Pant, there is a twin condition. Let
Yes,
us
Your Lord.
see, once it is there, the records are there.
Yes, Your Lord.
Line to line.
Yes, sir.
The respondents are directed to bring on record, produce the records on the next date without fail. It is further observed that in the circumstance, this court shall further consider as to whether any interim directions are required on the next date.
Oblige, Your Lord. Oblige. Okay.
Item 49.
What is this?
I have submitted the tender, my lord.
Huh?
I have submitted the, my lord, bid, my lord, for my lord, Bharat LPG transposition of the contract, my lord. In my lord, I have, my lord, selected for the technical bid, my case was, my lord. I passed the technical bid, and subsequently I also, my lord, cleared the price bid also, my lord. Sorry, my lord, the price bid also. My price bid was open and I was selected. Then, my lord, what happened? They made a query, my lord. And query they have asked, instead of, my lord, farm registration, I have given partnership bid, my lord. I have given reply, I have given this partnership bid. They accepted. LOA has been issued. So, a vendor code also issued, my lord. LOA is also issued to me, my lord. After that, my lord, they have not issued the work order till today, my lord. Your lordship, kindly go to the, my lord. I want to show the document, my lord. Your lordship, first kindly go to the, my lord. Vendor details, my lord. Yes, my lord. Your lordship, kindly go to the page 138, my lord.
Why are you apprehending that they are going to cancel?
My lord, I am apprehending reason behind it. There is a surreptitious move on the part of the respondent, my lord, that I shall be, my lord, my tender should be cancelled, my lord. That is why I am coming before lord.
So it is on an apprehension. So you are on an apprehension.
Yes, my lord.
So why should we entertain this type of writ petition?
I am waiting so much long time, my lord.
No. So what is so much of long time? For how many years you have been given the contract?
It is for, my lord, 12 months, my lord.
12 months?
Yes, my lord. It's the 14 June 25, my lord. It was called.
No, how many, for how long is the contract?
5 years.
5 years. Then
Yes, my lord.
you get it for 12 months.
Yes, my lord.
Why are you apprehending? They will take it. If they don't, they cancel it, you come up. We are waiting for you. And if you have anything, how can this court direct them? Okay, you give it to them. That is there absolutely within their domain.
I want to.
No, no, Mr. NNB Chaudhary, kindly, no, Mr. Chaudhary, kindly show me a provision
Only thing.
that it is a duty on their part to issue you the letter of the work order. Show me that provision.
Actually, my lord, what happened, my lord, sometime, my lord. I come in the, my lord, yesterday night I come to Guwahati, my lord. I on impression that Mr. Kane should do, my lord.
Okay, we'll wait for Mr. Kane Chaudhary and dismiss it in his hands.
Yes.
Hello.
Same,
Same matter.
exactly same.
Time being. Get your senior.
Updated item 58.
Yes, where is he? The standing counsel of Mr. Ziaul Pasa? Where is he? The standing counsel of Mr. Ziaul Pasa? My goodness. Okay, Mr. Chaudhary. He says that he doesn't want the dismissal in his hands and overnight he has traveled, so he wants the dismissal in your hands. But Mr. Chaudhary, tell me one thing.
Yes.
How can this court issue a mandamus directing them to issue the work order?
No, my lord, our only prayer is, my lord. Work order has not been issued.
How can this court direct?
My humble submission is, if your lordship is satisfied with the reasons to furnished by today, I'm praying only for a notice. I'm not praying for any interim order. Already I'm
No,
asking for
there
a
cannot
notice.
be an interim order.
No question, because it's a final decree.
But why should this court, yes, tomorrow, you see, can this court compel them to issue a work order?
No. If, my lord, for some administrative reason they're not giving, then no. But if for reasons which is violative of Article 14, certainly lordships can. If it is for some administrative reason, for example, they take a call, no, we will not process this tender any further, therefore we are not issuing. Then it's
No,
okay.
for that they have to cancel the process.
Exactly. So what I'm saying is, my lord,
But if they have not cancelled it till now,
no,
so you
that's why,
come.
no, my lord, there, I'm sitting over it, I have procured the vehicle, everything is ready, they have inspected my fleet of vehicles, same vehicle, my lord. Now they are sitting over the matter. All that we want to know is why. If your lordship is satisfied with the reason to be, then lordship will say, will not give any relief. If the reasons to be disclosed is arbitrary, then lordship will ask them to issue. That's all. I'm not saying for anything else, my lord.
But this court can't issue that writ
No, my lord, the mandamus can be issued.
to give them a work order.
No.
Not
No,
possible.
then our representations are pending. That also they are not disposing. My lord, matter is very simple, my lord.
The matter I have understood, it is very simple. There was some tender issued, you participated, you have been issued the letter of acceptance.
No, no. Actually, the issue is regarding some farm registration certificate.
But anyways, you have
that
been
is the only
issued,
point.
you have issued a letter of acceptance.
Yes, LOA has been issued.
On 16/9/2025, and till now, you have not been, they have not issued the work order.
Two things. my
And
lord,
you
work order and
apprehend,
agreement.
and you apprehend that they may cancel it, for which you need you have asked for a prohibitory form of.
I'm prohibition. All the time I want to know it.
No, there is you are asked, there's a second prayer out there not to cancel.
I'm not pressing that prayer. All that I'm asking for a notice, let them explain why they have not issued. That's all, my lord.
Yes, why have you not issued?
My lord, the petitioner was served yesterday. I have got some instruction. If your lordship kindly comes to page 243, that is the, my lord, letter of allotment.
243.
243, my lord. The clause 4, your lordship will kindly, my lord, peruse.
Yes.
to submit the documents, declarations, deposits as per tender completed in all respect to the office at the following address. This part has not been completed, my lord.
They have given. It is not correct. This is not correct. my lord. This is, there is no
Matter
dispute
over.
this.
That is your instruction?
No, my lord. In fact, I'll have to get further instruction. my
Okay, 2 o'clock. Only that is why you have not done it. That's all, we close it. Whatever matters should not be there. Mr. Chaudhary, we are having a constitutional day today.
Constitutional.
Constitution Day. But people out here, the lawyers out here, although have been urging on Article 14 and all, as you have made your speech also, they are not concerned about that Constitution Day. They are more busy sitting out there in the chambers.
Right.
We'll have it at 2. Yes, what do you want? What review?
My lord, I have informed Mr. Gogoi, my lord.
What is wrong with this order?
My lord, actually that format, my lord, that date format was, my lord, in some apps, my lord, it shows as, my lord, month, first month, thereafter day, my lord, thereafter year, my lord.
What?
On the date of decision, my lord, I have already asked the petitioner, my lord, send a photograph, my lord. In this photograph also, my lord, the date was shown, my lord, 9/26/2025, my lord. It is in their apps, my lord. It is in the format, my lord.
Yes, what is the ground?
My lord, the ground, my lord, I have taken, my lord, that format, my lord. Sometimes, my lord, it comes, my lord, like that,
Huh?
my lord. In some apps, my lord, photography apps, my lord, it shows, my lord, first month, thereafter day, my lord, thereafter year, my lord.
So,
So, my lord, is that,
why did you get it in this manner? Is it written?
my lord,
No, is that the format?
my lord, it is intentional.
No, is that the format?
My lord, in some apps, my lord, it shows like that.
There's no format. You kindly see it's 9/5. Why should we say it to be 5/9?
My lord, because my lord, kindly see the last page, my lord, 206, my lord, page number 206, my lord.
Page number?
Last page, my lord, 206, my lord.
What?
My lord, in this photograph, my lord, that last date, my lord, when your lordship was pleased to dismiss, my lord, I have asked the petitioner to send that photograph, my lord. At the point, my lord, he was in Hyderabad, my lord. He has sent photograph, my lord. Here also, my lord, it was written as 9/26/2005, my lord. My lord, month, day, thereafter year, my lord. And even I check my desktop computer also, my lord, that's, my desktop also, my lord, setting it shows like that, my lord. And it happens, my lord.
But whether the site visit certificate was given?
No, my lord, not given, my lord. Because
So
they
why
know
should
that
we
this
look
is
into
the
it?
petition, my lord. And the-
Why should we interfere with this if you have not been given? It is their satisfaction. Why have you mentioned as 9/5/2025?
My lord. Because that package, my lord, that package had not yet opened, my lord. But in package one
But
forty,
isn't it the mandate that you have to have the site visit certificate?
but certificate he had submitted along with the photograph, my lord. Certificate he had submitted, my lord, along with the photograph, my lord. That earlier, my lord, that photograph, your lordship will find, my lord.
What was the last date?
My lord, last date was, my lord,
11/9.
yes, my lord. But In respect of package number 142, my lord, that has been decoded, my lord, cancelled, my lord, and 43 is still alive, my lord. 43, my lord, not opened, my lord. Package number 143, my lord.
Package number,
Packages are there, my lord.
package number,
142 and 143, my lord.
serial number 3 and 5.
Yes, my lord.
So 5 is alive.
Yes, my lord.
You have taken some order on 13/8.
Yes, my lord.
What is that order?
My lord, that order, when I was allowed to withdraw, my lord, with liberty to take photograph, my lord. And on that very date, my lord, the petitioner visited the site, my lord, he had taken photograph, my lord. And on the date itself, my lord, that was, he had submitted, but it was received on the next date, my lord.
Lordship will see page 78, madam. 78 of the edition, madam. This is the format of the site visit certificate. There, my lord, specifically there is a space where, my lord, the date is to be mentioned.
Let us see. Name of the work as per published on so and so. What is your date? Mention.
It is available on Google.
It is essential.
What is this? Site visit? What is
Apply.
202?
Yes, yes.
Where is your site visit certificate?
My lord, I had ended, my lord. Take my certificate.
Ah,
Page
they have
182.
mentioned it.
182, my lord.
They have mentioned the date on
Yes.
5/9.
Yes, my lord.
Okay. So we review it. If it is not done,
If it is not done, ma'am, technical bit not,
absolutely. we will die. 141 is cancelled.
142, my lord.
141 is cancelled.
142, my lord. It is cancelled. 142 and 143, my lord.
they couldn't do it.
So if we review it, which package do you want now?
143, my lord.
Heard Mr. S. Hawk, the learned counsel appearing on behalf of the petitioner, as well as Mr. B. Gugoi, the learned standing counsel of the PWD. This is an application seeking review of the order dated 26/9/2025, passed in WPC number 5795/2025, whereby this court dismissed the said application on the ground that the photographs which were taken on the ground that this court, on the ground that this court, on the ground that the photographs which were enclosed to the, on the ground that this court, now by observing that the photographs in question were taken on 9/5/2025, and there is no explanation in the writ petition about the fact that the date and the month not properly mentioned. Full stop. Mr. J. Pasar, the learned counsel, Mr. J. Pasar, the Mr. S. Hawk, the learned counsel appearing on behalf of the petitioner, have referred to the site visit certificate as contained in the notice inviting tender. Mr. So-and-so submitted, Mr. S. Hawk submitted that in the site visit certificate, there is a requirement of incorporating the name as published in the NIT as well as the date of the visit of the site. Full stop. He further submitted that in the application which was filed by the petitioner before the executive engineer PWRD in Nalbai District Territorial Road Division, the site visit certificate was filled up and filled up by putting the package number as well as the date. And this aspect was not noticed by this court while passing the order sought to be reviewed. He therefore submitted that this is an error apparent on the face of the record. Mr. B. Gogoi, the learned counsel appearing on behalf of the petitioner, submitted a respondent PWD submitted that from a perusal of the site visit certificate, which was filled and submitted, it appears that the date of the visit was mentioned on 5/9/2025. So taking into account the above, it therefore appears that there was an error apparent on the face of the record in the in the orders dated 26/9/2024, for which this court therefore recalls the order dated 26/9/2024. Recall is not repetition got hanani. I can't pass that order, na? What you are asking?
It will be in the repetition.
Yes, that repetition is not.
Okay. Recalls the order dated so and so. 26/9/2025. Passed in WPC number 5795/2025. The registry is directed to list the writ petition. Writ petition being WPC number
5795.
5/2000. You do one thing, you make a mention memo. And let it be is directed to list the writ petition 5795/2024. Tomorrow. Tomorrow. Taking into account that there is an urgency expressed by the parties. If by tomorrow technical is open, you are finished. Oh, you should have, Mr. There are many things you cannot, I cannot review here and pass an order. Mr. Hawk needs to be more, you should be doing some civil matters.
Learning, my lord.
No, civil matters.
Right.
Then you will understand
My lord.
that what is the scope of review. I cannot pass an order
Yes, sir,
there.
my lord.
You need to. Next time I'm taking a bench one, I will make you some amicus in many matters.
Keep your.
My lord, my senior is on legs in court number 1.
You say,
My lord,
your senior cannot obtain instructions
My lord,
from the
we have
client.
obtained
It
instructions,
is
my
you
lord.
who have to
the
obtain.
instructions are on the way, my lord. The instructions are on the way. The instructions indicate, my lord, that certain documents have not been submitted as per tender
They will
conditions.
submit.
Instruction report.
I know my humble subject is that, my lord. We have submitted the document, my lord.
Page 2, my lord, of the mail trail, my lord. In their replies.
No. Mister, you have the, yeah? Since both the firms, read it, where is it? The last.
Since this
Since
document,
both the firms have not complied with this document as part of their initial bid,
my lord,
technical queries were raised to allow them an opportunity to comply with the PQ requirement. The details of the TQ and responses received are as follows.
my lord,
Reply dated so and so.
my lord,
In their replies, both their submitted certificates of registration issued by the Sub-Register Sadar Registration Office, Kamrup.
my lord,
These certificates pertain only to registration of partnership firms and not to registration of partnership firms itself, which is a mandatory requirement required under the PQ criteria. Now, therefore, the proposal is that you are not going to allow them. But if you are not allowing them, why you are allowing them to comply again?
no, my lord, what had happened,
You have taken now a stand out here
my lord,
to the effect that you are going to, you are not going to accept, that is your proposal,
yes, my lord,
not to accept
yes,
their
my lord,
LOI.
yes, my lord,
You have to cancel the LOI.
the
Have you-
LOA. yeah.
Have you cancelled the LOA or not?
We have not as yet, my lord. There is a reason, my lord. If your lordship may kindly come to page 239. Page 239 of the first writ petition, my lord.
Yes.
239, my lord, is the LOA, my lord, which was issued to the petitioner. If your lordship can kindly come to page 243. 243. As per tender terms and conditions, you are advised to carry out the following. My lord, then point number 4. To submit the documents, declarations / deposits as per the tender completed in all respect to the office at the following address. Now reading page 243, my lord, will kindly come for a moment to page 48. Page 48. Page 48.
Page 48.
48, my lord. It's a part of the tender, my lord. Page 48.
Yes.
Your lordship would see the first number, my lord, bidders. Offers may be submitted by point number 2, registered partnership firm, within bracket, registered with Registrar of Firms, Ministry of Corporate Affairs, consisting of Indian citizens. My lord, this was a part of the document that ought to have been supplied by the petitioners, my lord. That was not done. And the,
But tell me one thing.
my lord,
They may be registered now,
my lord,
which has happened subsequently.
my lord,
But you still permit proprietorship firm.
my lord.
You still permit proprietorship firm.
We do, my lord, if they're a proprietorship.
So prior to that, it was a proprietorship
No, my
firm.
lord, they applied as a partnership firm.
They applied as a partnership
lord.
firm, but they actually don't meet the proper, meet the area of a partnership because they were not registered as per, because it is a requirement as per section 69.
Yes,
But otherwise, wouldn't they come within the ambit of a proprietorship firm? A proprietorship firm, it is not the owner can be two, many, two or three can also be an owner of a firm.
my lord, as far as I understand, my lord, a proprietorship firm would constitute of one member, my lord. Here, the partnership firm, which has been arrayed as petition number 1, has been represented by 2 partners. And they portrayed themselves as partners in a partnership firm when they entered the. bidding
Okay,
process.
let us forget about the,
My lord,
you say individuals.
my lord,
If it is an individual also,
my lord, number 1, yes.
number one,
Yes,
individuals also can do it. It is a you are using a plural word.
yes, ma'am.
You are not using individual.
My lord. Individuals, proprietorship firms / individuals.
So therefore, if they don't come within the ambit of a firm
My lord,
registered,
my lord,
it may not come under 2(2), but they can come under 2(1).
my lord, my humble submission is that they could come under 2(1) provided there were 2 separate applications by 2 separate petitioners. Now, both the petitioners, in guise of a partnership firm, they preferred one application. And your lordship would read the context of individuals in context of proprietorship firms, my lord, adjust and generis, my lord, the context might be relevant subject to your lordship's final order in the matter. The individual, the word has to be construed, my lord, in the context of.
Firms. Okay, so this one is the unregistered partnership firms will be rejected.
Yes, my lord.
So then why you issued the LOA?
My lord, the LOA is subject to further submission of documents, my lord. That is indicated in the LOA itself, my lord. We can always cancel the LOA, my lord. We had given, that was a process subject to them fulfilling.
Then why you are not bringing that into the attention of them if they have submitted a representation?
Yes, my lord. My lord, your lordship will kindly come to page 139. 139, my lord. That was a query. That was a query to the petitioners. It is dated 14/6/2025, this letter, my lord. The date I can infer with the date, my lord, only by going to the table of contents, my lord.
No, have they submitted any representation?
My lord, there is a representation which is pending.
Then why you are not answering to them?
This representation was prepared on 12th of November, my lord. Not a long time has passed, my lord. In fact, 16/9/2025 is the date on when the LOA is issued. If a lordship gives us a time-bound manner to dispose of the representation.
Where's the representation?
My lord, the representation is at page 235. Because this issue was brought to our attention, my lord, on 15/6/2025 itself.
Okay. You consider this representation and dispose it off.
Presentation.
And you take a decision in line with this. I'm not going to say anything. You take a decision in the line, then they will challenge it.
Because tender conditions stipulated a certain criteria, my lord.
Mr. Sharma, I understand. I'm
Yes.
not going to pass an order to the effect that you don't do it.
My lord,
You want to cancel it, but you have to cancel the LOA
my lord, my lord,
and give them the reasons which you have mentioned
my
out
lord,
here.
my lord, my lord.
Huh?
My lord.
So then they also will know, then they will challenge it where they stand. Nothing more than
My
that.
lord, absolutely. My lordship, they do know where they stand because our reply is at page 140. They know. So it is already made aware to them, my lord, but we'll do as per your lordship directions, my lord. Page 140.
After that, LOA was issued.
Page 40 is the reply to our 139 letter, my lord, where they've stated that we do not have the registration certificate as yet, but we have submitted an affidavit on notarized stamp paper and the registered partnership deed. They know where they stand, my lord. And
No, anyway,
my lord,
when they give a representation, you answer to that.
My lord,
You
my
are
lord.
not going to. You have taken a decision
My
to
lord.
that effect. Give them.
my lord,
Then they can challenge it.
my lord,
Okay.
yes.
Heard Mr. K.N. Chaudhary, the learned senior counsel, assisted by Mr. N.N.B. Chaudhary, the learned counsel, appearing on behalf of the petitioner.
Kind permission, can I take leave?
Yes. Mr. M.K. Chaudhary, the learned senior counsel, assisted by Mr. M. Sharma, appears on behalf of the respondent numbers 226. Mr. H. Gupta appears for the respondent number 1. the issue, taking into account the issue involved, comma, and the instructions were placed by Mr. M.K. Chaudhary, the learned senior counsel, appearing on behalf of the respondents. This court takes up the instant writ petition for disposal at the motion stage. The case of the petitioner herein is that the petitioner, in pursuance to a notice inviting tender dated 18, no, huh? What is this? Dated,
My lord, the date is
dated
on page
1/3.
29.
1/3/2025.
My lord.
For transportation of bulk LPG by road from IOA DSO Assam base locations. In pursuance to the said tender process, the petitioner herein had participated. The tender was opened on 13/5/2025, and a total of 814 bidders participated by submitting their offers. Out of the 814 bidders, 113 offers were rejected due to various discrepancies such as non-submission of mandatory documents, failure to meet eligibility criteria, or deviations from tender conditions. The remaining 701 bidders, including the petitioner, were found technically acceptable and were shortlisted for opening of the prize bid as per the final technical evaluation. Pursuant thereto, the petitioner herein was issued. Pursuant thereto,
LOA is at page 239, my lord.
prior to that, they were your letter at 139, na?
139.
Pursuant thereto, the petitioner herein were directed to submit certain documents. What is the date?
My lord, the date is 14/6/2025, my lord.
And its reply has been 15 June 2020.
The reply is on the next day, my lord, at page 140.
If you also go to the page 138, my lord, also kindly look at my last part. Start time below portion, my lord. Start time 14 June 2025. And my lord,
Now, when was this page 139?
139.
14/6, my lord. 14/6.
14/6.
Because start time is the
How
date
do
of,
you get the date?
my lord, on
14/6?
page 138.
138, my lord.
Page 138.
One, please refer attached PDF, one required document, so and so, so and so, Deepak Singh at 14 June to 12:35 PM. And query reply has been submitted on 15 June.
Huh?
14 June 2025.
Pursuant thereto, the petitioner herein was asked to submit various documents on 14/6/2025, which included the copy of the registration certificate from the register of firms to establish the registered partnership firm, enclosing all the annexures wherein names of all partners of the said partnership firm are to be mentioned. The petitioner thereupon What did you, when did you submit?
15/6, my lord.
15/6, my lord.
15/6.
Same paper, my lord.
On 15/6/2025, submitted various documents. Including a partnership deed which was registered before the sub-register. Before the deputy register, Kamrup Metro. The record further reveals that on, where is the letter of acceptance?
My lord, page 239, my lord. Page 239, the relevant portion is at page 243.
On 16/9/2025, a letter of acceptance was issued to the petitioner in favor of the petitioner. And further, there was an advice
And security deposit also given. 2 lakhs.
to submit submit the documents, declarations, deposits as per the tender, completed in all respects to the office. The grievance of the petitioner is that the petitioner thereupon submitted those documents. Along with a registration certificate issued by the Register of Firms
Is it page 20?
on 27/10/2025.
My lord.
In spite of that, neither any work order has been issued nor an agreement has been entered into. And as such, the petitioner has approached this court seeking a writ in the nature of mandamus, thereby directing the respondents, number 2 to 6, to issue the work order as well as enter into the agreement. And further, also seeking a direction that the petitioner's bid should not be cancelled. It is further relevant to take note of that on 12/11/2025, the petitioner had submitted a representation to the respondent number
Respondent number my 3.
respondent number 3, general manager, na?
CGM.
Submitted a representation to the chief general manager.
Sorry, my lord.
Where is that? Where is the representation?
My lord, 235.
Huh?
Page 235.
Respondent number 2, page 230.
To the chief general manager, requesting for issuance of the work order as well as entering into the contract agreement. However, the said representation have not yet been disposed of. When the matter was taken up by this court was taken up by this court prior to recess. Mr. M. Sharma, appearing on behalf of the respondent number 2 to 6, submitted that the matter be taken up in the second half, a post recess, so that the instructions can be placed. Accordingly, the instructions by way of an email issued by the law officer of the respondent number 2 to 6, dated 26/11/2025, has been placed before this court, which is kept on record and marked with the letter X. photocopy korbo de, ikonoto rakhibo. From a perusal of the said instruction, it appears that the petitioner here, that the petitioner, though submitted its bid as a partnership firm, but the petitioner did not submit the registration the registration certificate issued by the register of firms It was also mentioned that though the petitioner was held to be technically responsive initially, but later on it was seen that the petitioner did not submit the registration certificate issued by the register of firms, and as such a query was made with the petitioner to produce the said certificate. It was further mentioned that the petitioner, instead of producing such certificate, had produced a certificate, a partnership deed registered before the deputy register, Kamrup Metro. And not the certificate from the register of firms. It was only on
2017. 27th of October.
12/11/2000, it was only on 12/11/2025, the petitioner submitted the certificate from the register of firms issued on 27/10/2025. It is further stand of the respondent in this, as could be seen from the instructions, that this certificate dated 27/10/2025 cannot be taken into consideration,
The last date was?
taking into account that it would violate the mandatory documents requirements defined under the technical bid of the subject tender. This court have duly heard the learned counsels appearing on behalf of the parties. It is the opinion of this court that the respondent authorities should inform the petitioner about its decision in reply to the representation submitted on 12/11/2025. Instead, keeping the petitioner in dark. Accordingly, this court therefore disposes of the instant writ petition without commenting anything on the merits of the dispute, but only with a direction to the respondent authorities to dispose of the representation submitted by the petitioner on 12/11/2025. and intimate the petitioner within a period of 15 days from today. It is observed that if the petitioner is dissatisfied with the reply, with the stand of the respondents, the petitioner would be at liberty to approach this court.
We have deposited security deposit. That may be-
What?
Security deposit we have given, my lord.
So what? How does it matter? They will return you the security deposit. You see, let them intimate you. And then I'm here to sit
That's
and you take up that ground which I have
My lord,
mentioned.
in the second case, my lord, that certificate is also not there, my lord.
Huh?
In the second case, there is a little difference in facts, my lord. That registration certificate has not been, my lord, submitted
My lord.
yet.
One of the condition is that, my lord, if I apply for that and if I give acknowledgement received, my lord, then that may be considered, my lord.
They have only applied,
I
but the
applied
certificate is not there.
as per that condition. Subsequently, I have applied, but partnership, this in respect of partnership position is same. Only thing, my lord.
Mr. LNB Chaudhary, partnership deed has no value.
Yes, sir.
It is an inter se between you and him.
Yes.
But the fact remains that for him to be interested, it has to be registration by firm. What is the difference in the other one? So there is
They
no
have not-
registration.
They have not, they have only applied, my lord, for the registration certificate.
ইয়াত
that has-
খালি সেইটো লাইনটো বদলাই দিব লাগিব।
Representation.
That here in this case, এইটো কৰিব that there is no registration certificate submitted. Here also date of representation 12/11,
Same, my lord.
12/11. খালি ইয়াত হল কৈ দিব that they have intimated that they have applied for registration before the register of firms.
For admission item 9. May it please your lordship, my senior J.K. Goswami is newly appointed in this case. So kindly fix the matter for next week.
None appears on behalf of the petitioner on call. What is the matter about?
Non-payment of contractors' bills.
What is this CBI doing, CBI, all this thing? What is wrong? Non-payment? Who? None appears on behalf of the petitioner on call. Mr.
M.K. Bora.
Appears on behalf of the respondents. Taking into account the above, for the interest of justice, the matter stands adjourned to be listed again on 1st of December 2025. It is observed that if the petitioner does not appear on the next date, it shall be presumed that the petitioner have lost interest in the instant proceedings and
Right.
appropriate orders shall be passed.
Then
What is this?
Here, my lord, our only silence before the our counter silence is that, my lord, we cannot release the EMD and SD because of arbitration cases pending before arbitrator. Now he has filed one affidavit, additional affidavit that has already been awarded. So let the matter come on Monday, my lord. I'll take the instruction whether they are going to release that amount or not, my lord. Because only our ground was only that, my lord. Arbitration case was pending.
Ms. Agayan submits that in pursuance to submits that an additional affidavit has been filed by the petitioner wherein the award of the learned arbitrator dated award dated
23/5/24.
23/5/2024 in arbitration reference case number 1/2023 have been enclosed. Ms. Agayan submits that she would obtain instructions as to whether, in view of the arbitration award, the respondents can still withhold the security deposit. List the matter on 8th of December 2025 for an update.
Master bless.
11.
May I please,
My lord, on payment of contractual bill, my lord. Respondent has filed an affidavit, my lord, recently. I would like to file a reply, my lord.
What do they say?
But they said, my lord, page number 56, my lord, they said they have not found some records, my lord, chalans and, my lord, have,
So what is there? Go there. Go to the civil court.
no, some of the amount they have released, my lord, only, some of the amount they have released. On that point also, I need to take instruction, my lord. As paragraph number 6, they have stated.
No. These are matters there, civil courts. We can't do anything. If they have not found out there, I can't help it. I can't. They cannot make the verification.
No, yes.
Mr. Counsel, you have to understand, this court cannot direct them to verify. And if they, I cannot also direct them to pay.
One said they had
Yes, you. Mr. Bhattakur.
requested to submit the challan copies and the official receipt of the materials, my lord. On that point, my lord, whether my client has submitted or not, my lord. Page 57, my lord, paragraph 5.
Further in respect to the other report having found what the official to supply that challenge and official receipts. So you want to go and submit?
Yes, my lord, I can.
If they
submit it.
submit, you are going to consider.
Yes, if they
My lord, yes, my lord.
submitted, no.
Some of the amount they have released, my lord, they have said, paragraph 5, my lord. Till 9/11/2021, my lord.
এই ওপৰখিনি লিখি দিব হা এইটো non-payment of dues তাৰপিছত লিখিব it is seen that the respondent number 4 has filed an affidavit in opposition wherein it has been mentioned that in respect to the work order dated 9/11/2021, the said amount have been duly cleared. However, in respect to other works, no records have been found about the official receipt of the materials and challan copies as claimed by the petitioner. It is also mentioned that the petitioner was requested to submit the challan copies and official receipts of the materials. In addition to that, it is also stated that reminders were also issued to the petitioner to submit such official receipt of the materials and delivery challan copies with signatures and seal of the receiving authority for the bills claimed by the petitioner. No. That cannot happen. You have to go to the civil court.
Take up on the next day, my lord, I will.
Absolutely not. Is this the court forum? Do this court look like a PHC office?
My lord,
No, does it look like? It is a big magnificent building. Does it look like a court PHC office? No.
but,
You go there, you do whatever it is. You have not submitted. So taking into account the stand
as stated in.
by the respondents that there is no record of official receipt of the materials and delivery challan copies with signature of the seal of the receiving authority for the bills claimed by the petitioner. This court is not in a position to direct the respondents in absence of such materials to carry out a verification and then to make payment. Considering the above, this court therefore is not inclined to entertain the instant writ petition as it would involve going into various aspects pertaining to disputed questions of facts which are required to be proved by way of evidence In that view of the matter, the writ petition stands dismissed. Next. Before parting with the record, this court, however, observed that the dismissal of the instant writ petition shall not preclude or prejudice the petitioner to approach the competent court of civil jurisdiction if so advised and permissible under law. তার আগরখিন লিখি দিব। The present decision writ petition filed claiming an amount of rupees 40,59,478 for various works completed by the petitioner. Also, they responded in affidavit conclusion.
Regarding the payment which is admitted by the respondent, that was also not clear from the.
Go there, interest they will give. This court is not going to look into.
At least some liberty may be granted till then they.
I've given you the liberty.
To approach the civil court.
And also say that shall not preclude and prejudice you to move the competent court of civil jurisdiction if so permissible under law.
All right.
Yes. Your Pasa, where is it? Yes, standing counsel, what is your case?
Then, my lord, this is, my lord, what happens, my lord, the petitioner, my lord, is one of the dumper, my lord. It usually carries, my lord, sands and, my lord, stone crust, my lord. And it works in cubic meter, my lord.
What are you asking for? Let us see.
Now, my lord,
Your Pasa has the habit. Directly they have to measure the loaded dumper with sand and crushed stone instead of kilograms. What is this, madam?
Lordship, we have filed affidavit. Lordship, may kindly dispose of this matter. We have filed affidavit, Lordship. 2 affidavits we have filed, my lord.
What is this affidavit for? For respond number 6.
5 and 6, both is filed separately.
What do they say?
Same stand. Paragraph 4 onwards, page 24, my lord. They say it should be in cubic meter, but as per rules, it should be in kilogram, and we are measuring as in kilogram.
Okay.
now, my lord, what happens, my lord, the sand, my lord, usually purchase, my lord, sand.
Huh?
Sand for construction person, sand, my lord, the river sand, my lord. These are what in cubic meter, my lord, cm, my lord. And stone crush also in cm, my lord. Now the body is of capacity of 16 cubic meter, my lord, cm. When it loads, my lord, the sands or stone crush, my lord, it measures in the cubic meter, my lord. So it get loaded with 16 cm. It calls 16 cm when the body is fully covered with sand, my lord, or stone crush, my lord. Usually, my lord, whenever a building or a sand, my lord, the sand are purchased in cubic meter, not in kilogram. Now, my lord, the condition is that, my lord, when sand is, well, filled like 16 cubic meter body, it fills with 16 cm of sands, my lord. Now, when it get weight, my lord, definitely it will be in kilogram, it will be more, it will exceed the limit, my lord. Now, is the condition, my lord, under such condition, my lord, what will happen, my lord? Definitely, my lord, sands, lands, whatever, my lord, it measures with the cubic meter, my lord. Now, this is the peculiar.
So,
feature, my lord.
how do you measure? Just for example, how do you measure water?
Water is in liter, in liter.
And if the truck, you put it inside the truck,
My lord.
are you going
Yes,
to
that
measure
is
in
also, yes,
liters?
water tank-
No, I am asking you, are you going to measure in liters?
No, in water, it is as liter.
How will a truck be weighed
My lord.
with CUM? No, tell me, I understand. the measure how sand is taken is CUM.
Same, yes, my lord.
But if you put it inside a truck,
My lord.
you require the truck to be weighed.
Yes, yes.
And how will you weigh the truck weight?
Including the
CUM,
TM.
possible?
Yes. Now.
No,
Possible.
possible.
No.
Unnecessary.
They are taking together, my lord, becomes overweight, my lord, they're taking the sand. They are imposing. penalty.
Therefore, we will consider that measure that tanker also
Not tanker,
in
my
liter.
lord.
No, in liter.
Yes, my
In
lord.
liter.
My lord, in,
You,
sand, my
you
lord.
do one thing. Have you made the motor vehicles, have you challenged the provisions of the Motor Vehicles Act?
No, my lord. No. But.
You need
section-
to.
Section one.
You, we give you, Mr.
My lord.
You do some social service now, except jail person needs to do some social service. So you give you the liberty to withdraw with the liberty to challenge if so advised. Challenge these provisions.
Yes.
Then it will be helpful for others also.
Now, my lord, or that effort.
There's no other, there's nothing else.
Yes.
My lord.
Because there's no concept of in the
Yes, yes,
rule.
my lord.
Yep,
Then-
like that.
I appreciate that. But the aware of the imposing penalty, my lord, it is not as per law, my lord. Law says, my lord, section 113 says, my lord, if it is excess in weight, my lord, should be offload. But there is no such provision of imposing penalty. One of three, my lord. Okay, yeah.
Paragraph 5 of page 25, Lordship, we have replied.
Mr. Hawk,
Well,
your prayer is where?
Page,
What is your prayer?
page 12.
yes, my lord.
You want to challenge the penalty, challenge the penalty differently. I'm waiting for you.
Yes, yes.
But why should I look into the penalty aspect in a writ petition
Yes,
where you are
yes.
asking this?
Penalty we can say.
Huh? So what do you want? Dismiss, withdraw, which one? With liberty to challenge.
Yes. With liberty to challenge, my lord.
Rules.
The rules in, as well as, my lord, that.
Heard,
penalty,
Mr. Huh?
As well as the penalty.
Penalty is not the subject matter here.
Yeah.
If it is not the subject matter out here, how do you take it?
Yes, it's not subject.
Heard, Mr. Ashok, the learned counsel appearing on behalf of petitioner, Ms. M.D. Bora appears on behalf of the Transport Department. The petitioner herein, who is the owner of various dumpers, have sought for a mandamus, thereby directing the respondent authorities to measure the loaded dumpers with sand and crushed stones. In CUM, C is capital, U is small, dot capital M, instead of kilograms. First look. An affidavit in opposition has been filed by respondent number 6, wherein it has been mentioned that the Motor Vehicles Act 1988 and the rules framed therein under do not conceive of weighing the motor vehicles as per CUM, but rather the weighment of the motor vehicle a loaded motor vehicle, loaded or unloaded, is to be made on the basis of kilograms. In that regard, reference is made to section 216, 2(17), 2(21) of the Motor Vehicles Act 1988. Taking into account the said stand, Mr. Hawk, the learned counsel submits that the petitioner would not like to further proceed with the instant writ petition. And the petitioner would be well advised to challenge those provisions if permissible under law. Accordingly, the instant writ petition stands closed on withdrawal. Liberty, however, the withdrawal of the instant writ petition shall not preclude the petitioner to challenge the provisions of section 216, the provisions of the Motor Vehicles Act 1988, which stipulate that the weighment of the vehicle, loaded or unloaded, is to be made on the basis of kilograms.
Kilograms. Deeply obliged, Lordship.
Item 16.
May I, Lordship, please?
What is this?
May I, Lordship, please?
Tell me.
Lordship, this matter is converted the contractor's bill by the Assistant Labor Commissioner in a Bakijai proceeding. Lordship, kindly have a look at page 25.
What is this? Requisition of what?
Assistant Labor Commissioner, my lord, take up the issue of non-payment of contractor's bill. Yes, and he has issued a certificate for realization under the Bengal's Public Demand Recovery Act. Kindly have a look at page 25. Absolutely misuse the power. Lordship, kindly have a look at subject. Submission of certificate for realization of pending wages payment. With reference to the above, I have the honor to state that the management of such and such has failed to pay outstanding dues to various contractors.
Yes, madam. How do you
And all-
protect this type of things?
My lord, because of the contract.
This Assistant Labor
Con-
Commissioner has become, he has
Adjudic-
become the civil court
My lord, because
and
it's-
also the executing court.
The Lordship, kindly have a look at certificate. All the person, they are all firms. They are the contractors. Page 26, my lord, kindly have a look.
Very sad, madam.
My lord, but they have
What
considered
affidavit
this
these
as
people have filed?
contract.
Let us.
And the Assistant Labor Commissioner has supported by a counter affidavit.
Yes, my lord.
Assistant
He's
consider
Labor
the
Commissioner
affidavit.
says that demand the withdrawal payment from issue forwarded by the district court regarding non-payment outstanding billing.
He says comes under the contracts.
Does the
Labor-
Labor Commissioner have this power?
My lord, I also, my lord.
Who is the great person who has filed the affidavit?
My lord,
Commissioner, senior government advocate, you have filed.
I have filed because Assistant Labor Commissioner is the
Didn't you
party. my lord.
suggest that this type of thing is
My
not
lord,
permissible?
he has prepared it and my lord,
This is not under the Payment of Wages Act.
my lord.
This is for non-payment. Why you are going to the
contractors
Payment
In-
of Wages Act?
In a lighter mood, my lord, he is a lawyer. In fact, he is an LLB, he is a degree of LLB, my lord, this Assistant Labor Commission.
My lord,
So therefore, he has prepared himself.
contractors could not
But
pay the
why should
labor.
they? This is a demand of how much? 6 crores.
My lord,
Okay. We should not dispose of in a manner by which the council is appearing through the virtual mode. Huh?
Right.
We dispose it on when the council appears before the courts.
On 8th, on 8th of December.
On 8th, we finish it off.
Right. I'll be happy, my lord.
This type of wrong, this is absolutely wrong. Because we have to quash not only this as well as the Bakija proceedings also.
yes, ma'am, because otherwise this will be continued. Because
Page
contractors
65.
could not pay the wages to the laborers, so that's why.
No, this is not the issue. This is not the issue. They are
Nothing
bills.
to do with payment of wages.
Yes.
They are bills.
This I would have understood.
My lord,
If there is any wage concern, they can very well do whatever may be. But then also there are doubts to that effect how it is to be construed. It is
And
under the-
payment of wages,
my
there
lord,
is no
while-
provision.
while my
Under
lord,
the
for
payment
the
of-
Page 91, my lord, he has, my lord, the deponent has stated that wages means, my lord, that because means all remuneration, whether by way of salary, allowances or otherwise, expressed in term of money or capable of being so expressed, which would, if the terms of employment, the term of employment expressed or implied, were fulfilled, be payable to a person
Madam.
employed in respect of his
if
employment.
Person concerned brings the non-payment of contractual dues within the term of wages, I have serious doubts in respect to the person's qualifications
Lordship,
or understanding.
Lordship, it is his stand
It is a
because
very
he has
difficult thing.
issued this, my lord.
Yeah, he himself writes. Multiple of the various contractors engaged by them after providing multiple opportunities where they ought not to have. No.
And my lord, page 79, he has said non-payment of earned wages. Subject is like that, so that's why
No,
it's calculated as wages.
He now realizes what he did is wrong.
My lord.
So, but to save his face, he has mentioned you must have also felt.
My lord, because
No, you must have also felt that how can a government official be of such a
My-
person
my-
may not know the law in this manner.
my lord,
So you must have thought that let us put some wages
his
business
stand, my
also.
lord, his stand why he did so, my lord. It is
How is it possible, madam?
correct, my lord, because
This
it's a
depot,
contractor's bill. He could
my
have-
lord,
He could have
this,
filed writ petition claiming contractor's bill.
he has annexed the relevant
Anyways,
pages.
do one thing,
Ma'am.
we'll have this
Ma'am,
Oh, 8th of
Thursday, tomorrow. Thursday, no? Tomorrow?
tomorrow, ma'am.
So some.
My lordship, kindly fix it on 8th or 9th, my lord, any day.
No.
Okay,
We finish it up tomorrow,
Okay.
Thursday at 2 p.m. Like you
Okay.
need some during on a Thursday and Tuesday, I take up certain matters on a very serious note, but you need to relieve yourself with some tension. So these are the
My-
matters by which you can relieve your tension. List
My
the matter
lord.
tomorrow at 2 p.m.
Grateful, man.
We'll dispose it of tomorrow.
My lord.
On behalf of Mr. K. Gogoi Malak, maybe fix on Monday, Malak. He has not received the instruction, Malak, and he requested to pray before your lordship on fixing the matter on Monday, Malak.
Monday,
Monday, Malak.
affidavit not filed.
No, Malak, he hasn't received instruction, but he is expecting, Malak, by tomorrow he will get it, Malak. He is in court number 1 for a date reference case, Malak.
At the request of the learned counsel for the petitioner, for the respondent. Now, it is seen that no affidavit has been filed on behalf of the respondents in spite of notice being issued as far back as on 21/12/2023. The counsel appearing on behalf of the petitioner expresses urgency, taking into account that the petitioner is a 75-year-old, is a senior citizen. Taking into account the above, list this matter on 8th of December 2025. It is observed that if no affidavit is filed, this court will proceed by applying the doctrine of non-traverse
Obliged.
18.
before the next date. No affidavit filed on or before the next.
Non-payment of contractual liability.
Chief,
Kiwa matter, ma'am.
within a period of 2 months, we will.
6 months.
6 months, okay, your lordship.
You have that order?
I'll provide, madam.
Disposed.
Obliged.
You provide.
Yes, madam. Right now,
19.
My lord, his grievance has been redressed.
He is, hold on, my lord.
What happens in this?
What
case,
has been dismissed?
My lord, EC has been granted. EC is there, EC has been.
EC was earlier rejected, my lord.
Yeah, it
Earlier
has been
rejected
granted.
because of modified GPS. The DFO has modified the GPS earlier given in the letter of intent as well as the agreement.
এখন দি দিবচোন।
Till now, our দিয়া নাই।
দিব। My lord, I had,
এতিয়া দিব।
my lord, I had rendered my legal opinion after this pending of this case. After EC had come, the DFO had asked for us legal opinion that he can be allowed to operate. I have sent it last week. It is on the process. His main grievance was non-issuance of the EC. EC has come because there was some changes in the location of the concession area.
And my lord, from April 2024, I have not been given to for operation. I have paid all the KIST money. Till date, I have paid all the more than 6 lakhs. Because of not rejection of the EC. And now EC has been granted on demand, my lord. EC was granted on 11/9/2025. And till date, I have not been allowed to operate, my lord. Lordship may kindly see the letter. I have requested the DFO and DFO has sent a letter to me, my lord.
Sir?
See, without the EC, you cannot run.
Yes, yes, my lord. The EC is mandatory. EC
Now what do you want?
my lord.
Now you got the EC.
EC was rejected, my lord, because of
No,
modified
Mr.
GPS.
Sharma, now you have got the EC.
Yes, EC was.
Now the EC is valid up to what time?
Up to the date of expiry of the Mohol money. That is my.
What is the expiry, Mohal?
April 2026. My lord, my only immediate prayer at this stage, since AC granted, I have already applied for renewal of the. my lord-
Extension,
My lord,
not renewal, extension.
extension, there is no provision, my lord.
So then,
For the EC already granted, my lord, EC granted.
Hmm.
Now, after the expiry of the mall period, my lord, I have paid for renewal because of compensate the loss, my lord.
On 17,
18 months prior to that, I have paid 1 lakh rupees fees and deposited them. That is maybe considered after the expiry of the mall. Considering that, my lord, my lord, this is the rule 20, renewal of contract is there, my lord. Provision is there, rule 20, my lord.
of the,
Renewal contract is there, my lord.
Assam Money
Consider significantly, pass. That is,
my lord, that
I need
is, he's not, his pleadings are restricted, not, doesn't go there. It is restricted to his non-furnishing of his EC and that we didn't allow him to run. Now, since my lord, the matter was sub judice, EC has come, we have given a furnishing opinion on 17/11. That let him run. Things take time, lordship can fix it perhaps by next week. To ensure that he gets to run, that's all, my lords.
he gets the,
He gets to run the area till his
Yeah, but-
expiry and other aspects are not to be
what we
touched,
extend,
my lords.
my lord, I have paid 6 lakhs rupees. So that,
you
not-
may
I am
ask,
not
you may
practicing-
ask for remission.
my lord,
You may ask for remission. Where is the question of extension?
that order may be, my lord, that
Why
order
should
may
I
be-
pass an order? You,
Oh, my lord,
when it is,
we have
it would be, it would be,
consequence.
no, if you don't ask for the, why should I? Anyways, we'll
I
do
have
28.
applied for, my lord, renewal.
As you have now got the EC,
EC.
but you have not been able to work now.
Till date, my lord, till date, I have not been allowed, my lord, already EC was done.
Now
Let me
opinion
see.
has been given to allow you
My
to
lord.
work.
Yes.
Like, the incident with petition has been filed by the petitioner.
Lordship got the EC, my lord?
This should issue.
Seeking a direction that the petitioner should be granted an environmental clearance for operation of the Kakoi sand, gravel and earth mining contract area for the period up to 22/5/2026.
That is a renewal period, my lord.
And or return the KIST money deposited with the office of the DFO for the period with effect from April 2024 till date. That is the period for which the DFO restrained the petitioner from operating the minor, what is it? Mineral concession
Area.
area for want of EC. And further seeking direction upon the respondent numbers 2, 3, and 4 to allow the petitioner to submit application for renewal of the mining contract in Kakoi sand, gravel, and earth mining contract area for suitable period, and consider the same sympathetically for granting renewal of the mining contract after the expiry of the present settlement of the petitioner on 22/5/2025.
My lord,
It has been submitted that during the pendency of the instant writ petition, that the environmental clearance have been granted to the petitioner
26
on
or
11/9/2025. The said and the copy of the environmental clearance is kept on record and marked with the letter X. Mr. D. Gogoi, the learned standing counsel of the Forest Environment and Forest Department of the Government of Assam, had submitted that he had also rendered an opinion for permitting the petitioner to run the mohol in question for the settlement period, for the remaining settlement period. And he submits that there is all likelihood that the same shall be permitted within a few days. List this matter on 8th of December 2025 for an update.
Always.
May I pray for my lord?
10th?
10th, my lord.
Yes.
20.
In this case, the settlement of a market measure. Lordship already held that the settlement ought to be settled within 10% of the last 3 years average settlement value. And in this case, the settlement is made to over the 10% of the last 3 years average settlement value.
Huh?
In this case, the settlement has been made above the 10% of the last 3 years settlement value.
Has been given to somebody.
Yes, Miller. To the respondent number 3, Miller. That is the respondent. And it is an admitted fact, Miller, that I have annexed the amended provision at page 26, over the part at page 27. Miller.
Where is that?
Page 27. Miller.
What is the settlement period?
It will be only 1 year. 1 year. And Miller, the close at page 32, Miller, close 12. In case of any also tender.
What is your name?
Miller.
Sakinur Hassan.
Then your lordship come to page.
Where are you? Sakinur Hassan, you have quoted 1,09,285.
85.74. And their value is the 1,09,000. That is serial number 3, Nan Mani Rabha. Are quoted value of 1,09,000.
Whom it has been given?
To the resolution number 3.
Who is he? What is the name?
Nan Mani Rabha. Serial number 3.
On the basis of a lottery.
Yes, ma'am. Because the other 3, that is serial number 1, 2, and 3 are the same value.
So as per you, he having quoted 30 paisa above the 10%.
Yes, ma'am. Because
so we should interfere.
Ma'am.
Absolutely.
Because your lordship has already held that it should not be. Since it is more than 10%, and everybody try to.
What is the last 3 years settlement value?
Yes, madam.
Where?
I have given, madam.
No, has it been declared?
Yes, madam, already settled, madam. Yes, page 40, madam.
Huh?
Page 40, 40.
40.
Yes. 2022-23, that is 98,054 rupees, then 23-24, 99,999, then 24-25, 99,999.
So it has been given 10% increase value is 1,09,286.
It is wrongly calculated.
So are you challenging this notice?
Yes, because since it is not more than 10% average value, So it is मतलब illegal. settlement.
Absolutely, no. Chalo. Bad case.
Lordship already held. मतलब
I understand, but this is the notice. You see, this is the notice being issued in terms of Rule 47(1), isn't it?
yes, my lord.
47 or 48?
47.
47(1). Now, in terms of 47(1), when they declared it to be 1,09,286, and they have quoted 1,09,286, 10% increase value is 1,09,286. Why you did not challenge it at that point of time?
Because मतलब the after that मतलब the settlement all has been met.
In that case, urge Mr. D.A. Kayam, the Lalit Council, appearing on behalf of the petitioner. Who appears for whom?
Agar what मतलब lordship already held that मतलब it is not more than मतलब 10%. This
Don't worry, I'll make my order clearly here. Appears on behalf of, who appears? You?
Lordship A.K. Ghosh on behalf of Mr. S. Datta.
You are appearing for which respondent?
1 and 2.
Mr. So-and-so appears for respondent number 1 and 2. Yes, for respondent number 3. The petitioner herein is agreed by the settlement of the Erabari bi-weekly market for the year 2025-26 made in favor of the respondent number 3 on the ground that the rate quoted by the respondent number 3 was above 10% of the average of the last 3 years settlement rate. Pustam. This court have duly taken note of that in pursuance to the notice inviting tender, the secretary of the Tetelia Bebesia Gaon Panchayat had issued a notice in furtherance to the notice inviting tender, had issued a notice dated 17/6/2025 in furtherance to the notice inviting tender dated 7/6/2025, wherein it is being mentioned that the 10% increase value would be rupees 1,09,286. It is the contention of the petitioner that taking into account the last 3 years settlement rates, that is for the year 2022-23, 2023-24, and 2024-25, to be rupees 98,054, 99,999 and 99,999 respectively. The average value is rupees 99,350.67 and 10% increase is rupees 1,09,285.70 paisa. Isn't it?
73%.
73 paisa. And as the respondent number 3 have quoted rupees 1,09,286, the respondent number 3 could not have been granted the said settlement by the respondent authorities. It is the opinion of this court that in the notice stated 17/6/2025 categorically mandates that the 10% increase value is rupees 1,09,286. And under such circumstances, it is not for this court to exercise the jurisdiction when, and under such circumstances, it cannot be said that the respondent's number 3 bid was disqualified in view of he having quoted 1,09,286. Under such circumstances, this court does not find any merit in the writ petition for which the writ petition stands dismissed. Whose the interim orders, if any, stands vacated.
Published. 21. Deeply obliged.
My lord, in 21, 22, and 23, my lord, the respondents have filed affidavit, my lord. We received only on Monday, my lord, 24th, my lord. 2 weeks time.
What is your stand?
My lord, regarding item number 21 and 23, we have no record of any such work order. And regarding item number 22, it was, as time was the essence, the work was to be completed within 30 days. But it took time of 3 years. So automatically due to his lapse, my lord, the portal which pays, my lord, the portal where the work is uploaded, it got closed, my lord. The contract said complete within 30 days. But it was awarded in the year 2020, but it was completed in the year 2023.
Then why did you ask him to go ahead and complete it?
Now,
is there not an interdepartmental communication or any communication to him that you complete it?
Now, since there might be denial, but admittedly it's working. Admittedly, it's with us now. This plant is running. So in that case, but it's admitted.
If it is admitted, pay that. How you pay it, do however it is.
Item 22, they have, my lord, annex 1 letter, my lord, page 20. So in the last part, it is stated this, so the division could not process his payment of amount so and so.
The portal was closed.
Informed to the undersigned.
Okay, let us.
For clearing.
No, madam, first of all, verification report, work order of bulk flow meter has already been issued by so and so. What is this? Annexure A to your affidavit in item number 21?
21, yes, sir. My lord, 21 we are denying, my lord. There's a report. My lord is taking up item number.
22, there is a letter.
No, I'm on 21 or sit under the
21. 21, my lord, we have annexed a chart.
that is what is this? Work order of bulk flow meter has already been issued by the work order dated so and so. Means that is some other work order.
Some other work.
Heard Ms. S.B. Chaudhary, the learned counsel, appearing on behalf of the petitioner. And Mr. D. Gogoi appears on behalf of the PHE department. The petitioner herein have approached this court seeking a direction.
No, 22.
That the petitioner seeking a direction for payment of
1,55,000.
various amounts in respect to the works carried out by the petitioner. Inasmuch as the petitioner having represented, the respondents have not paid such dues. Pursuant to the filing of the incident writ petition, an affidavit has been filed by the respondent number 7, wherein it has been mentioned that after carrying out the due verifications, there is no admitted dues to be paid to the respondent, to the petitioner. In that regard, a chart has been enclosed, a verification and report had been enclosed as Annexure A to the said affidavit. Under such circumstances, it appears that there are disputed questions of facts as to whether the petitioner is entitled to the said amount. in that view of the matter, it would not be in the interest of justice for this court to pass any directions as has been sought for. Accordingly, the writ petition stands dismissed. Liberty, however, is given to the petitioner. Now, the dismissal of the instant petition shall not, however, prejudice or preclude the petitioner to avail remedies before the competent court of civil jurisdiction if so advised and permissible under law.
My lord, I have received some documents, my lord, in support
Wait,
of my case.
What is the other one? 23 also same,
23 no records, ma'am,
same affidavit.
same affidavit,
Huh?
same affidavit.
Now 22 is the question where you have admitted.
I'll file my affidavit, my reply.
Wait, 22 is what?
22, it's admitted, but could not be paid because the portal had closed.
Where? Item?
My lord, affidavit lordship will take, my lord. The paragraph 3, my lord, we have spelled out. And we rely on a communication also.
And
Which is,
page 20, my lord, there is a communication, your lordship. May kindly see the last sentence.
Okay,
making the
20,
payment.
21 and 23 similar orders, huh? Now, in this case, we direct you to pay the, it is 1,85,000.
my lord,
Yes.
Okay, pay within 3 months.
my lord.
Heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. D. Gogoi, the learned counsel appearing on behalf of the PHE department. The petitioner herein has filed the instant writ petition, being aggrieved by the non-payment of an amount of rupees 1,86,506 in respect to the work order for providing FHTC from Lakhipur Water Supply for Lakhipur Water Supply Scheme under Silchar PHE Division Number 1 Silchar. For implementation of JM 2020-21 bracket 60 numbers. The petitioner, though were required to complete the said period work within a period of 30 days, and the same was done, completed only in the year 2023. But it is the case of the petitioner that after successful completion, the respondent authorities, however, have not paid the dues. And it is under such circumstances, the petitioner has approached this court. Pursuant to the filing of the instant writ petition, the affidavit respondent number 7 has filed an affidavit in opposition, wherein the amount of rupees 1,85,506 have been duly admitted. However, it is the stand of the respondent that the payment which was to be made to the petitioner was to be processed through an online bill submission portal. Taking into account that the work was completed in the year 2023, the online bill submission portal for the concerned work, that is Scheme Monitoring Tool bracket SMT portal, was closed for the concerned work under the Jal Jeevan Mission bracket JAMM in the year 2022. It was further stated that on account of the closure of the online bill portal, the respondents are not in a position to make the payment. So it is the opinion of this court that as the amount has been duly admitted, and the fact that the petitioner had carried out the work to the satisfaction of the respondents is not in denial. It is the opinion of this court that the petitioner is entitled, should be paid the amount of rupees 1,85,506. Accordingly, the instant with petition stands disposed of with the following observations and directions. The petitioner is entitled to the amount of rupees 1,85,506 from the respondent authorities jointly and severally. The respondent number
7. 7.
5 is directed to take effective steps for payment of the said amount of rupees 1,85,506 to the petitioner within a period of 3 months from the date a certified copy of the instant order is submitted to the respondent number 5. With above, the instant with petition stands disposed.
24.
This preferred for the non-payment of the contractual outstanding amount is 2,20,991. 991, dated 22nd February 2018. Lordship, the respondent has filed opposition. In their opposition, they did not deny about the claim of the petitioner, Lordship. They only mention about the late approaching late by the petitioner. But your Lordship, you have filed a reply.
Where are the work orders?
Work orders are running bills, your Lordship. Running bills are from page number 12 of the petition.
Huh?
Page number 12 to 46.
This is running account bill.
Yes, your Lordship.
Where are the work orders?
And the copy of liability statement for different work orders is on page number 47 and 48, Lordship. Where the petitioner was previously paid for this bill. Your Lordship, in page number 48. In column number 3, your Lordship.
No, I'm asking you, madam. You have to understand. Your basis is on the basis of the work order. You have to complete the work within the terms and conditions of the work order or some agreement. Your running account bill cannot suffice. Where is your work orders? What is your reply to paragraph number 6 of the affidavit in opposition? Where is your senior? Yes, you are there.
Yes, your Lordship.
Fantastic. You knew it that I would not otherwise dismiss, so you have a sitting for me.
Your Lordship.
No case.
As you got the work order, we may be given some time to file another affidavit.
How many affidavits? Go do one thing. Fight it out there in the civil court. I'm not doing it.
That is only 2-3 days, your Lordship.
You have filed one.
Yes, we have placed the work order, but the work orders are meant, as you got the conditions.
Paragraph 6 of the affidavit was very clear.
Yes.
And thereupon what order I have passed is also very
Yes,
clear.
your Lordship.
On 3/11,
Yes.
and thereupon you file a reply,
Yes, sir.
but not enclosing the work order. Then I give you again time. No. Then tell me.
That's a lapse on my part, your Lordship.
On your part or your petitioner's part?
On the part of the petitioner, I'm talking about the petitioner.
Yeah. So let the petitioner therefore fight it out in the civil court. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Miss So-and-so, the learned counsel who appears on behalf of the Water Resource Department. The present petition has been filed by the petitioner claiming an amount of rupees 2,20,991, which the petitioner claims that the same are due to the petitioner in respect to various contractual works carried out by the petitioner from time to time. It is pertinent to mention that in the writ petition, the petitioner have not enclosed any work orders. Additionally, it is also seen that these certain running account bills have been enclosed of the year 2018 and 19, from where it is very difficult to ascertain as to whether, as to what are the terms on which the petitioner was granted, were allotted the work, or for that matter, if any work was at all allotted. It is further seen that the petitioner thereupon slept over his rights, and on 24/4/2025, the petitioner received the liability statement issued by the Executive Engineer, Nalbari Water Resource Department, whereby it was mentioned that the petitioner is entitled to certain balance payments in respect to various work orders, various works. And it is on the basis thereof, the petitioner has approached this court by filing the present writ petition. This court, by an order dated One 2025 had issued notice. Pursuant thereto, an affidavit in opposition has been filed by the respondent number 2, wherein not only preliminary objections were taken as regards the maintainability of the writ petition on the basis of delay in latches, but also have submitted at paragraph number 6 that the petitioner claims that the work orders of the years 2018 and 19, but have failed to enclose the relevant documents in the present writ petition, from which one can come to a conclusion. When the petitioner completed the works, and also any representation duly received by the respondent authorities was filed by the petitioner to the respondent authorities for releasing his pending payment. It was also mentioned that in the year 2025, after receiving the liability statement from the respondent number 3, the petitioner has filed the writ petition. Pursuant thereto, the petitioner was afforded an opportunity to file a reply by specifically referring to paragraph number 6 of the affidavit in opposition filed by the respondent by the respondent number 2. The petitioner thereupon filed a rejoinder affidavit. However, this time also, the petitioner have failed to produce any work orders on the basis of which the petitioner claims the such amounts. Under such circumstances, it is the opinion of this court that without the work orders or any such documents being placed, it would be any directions so passed upon the respondents for carrying out any verification and then to make payment would serve no purpose, inasmuch as the said respondents, inasmuch as the petitioner himself has failed to produce the necessary documents. Considering the above, it is the opinion of this court that this is not a fit case for exercise of jurisdiction under Article 226 of the Constitution. Accordingly, the writ petition stands dismissed. Before parting with the record, this court, however, observes that the dismissal of the writ petition shall not, however, prejudice or preclude the petitioner to approach the competent court of civil jurisdiction, if so permissible under law.
25.
Assam T, yes, you are there.
The Lordship directed me to find the final opportunity, only one affidavit has been received. From the.
So if they have filed affidavit,
Only one, madam, the board, the government has not matter, and
Who?
the board's affidavit, there's a matter clarification by the government is necessary. In page
The
40.
finance affidavit is necessary,
huh?
madam. We have no difficulty, madam, but we approach the, because the.
Why the
finance-
finance not filing the affidavit?
Yes, sir, one communication we have received, my lord, that is the para-wise comment, my lord, furnished to the Assam Tea Employees Welfare Board. That has been furnished to us. Basically, my lord, they want, my lord, the 7-pay commission, my lord, benefits.
They were getting,
Yes.
then one fine morning you stop.
Yes.
So this, what is this corporation? Assam Tea.
The board, team
Board,
welfare
madam,
board.
welfare board.
Welfare. So
Assam
this is
Tea
under the
Plantation
AG,
Employees.
this is under the AG, do you sponsor, the government sponsors it?
Granting aid is given, man. Some granting aid is given. In fact, my lord, Lordship, may I have a look at this, my lord, this is the note of the Chief Minister of the state, my lord. He has stated that, my lord, if they can, my lord, bear it from their own, my lord, resources. Will see. Part of the, application affidavit, this is, But, my lord, here, affidavit of respondent one will be necessary. But they are, the main administrative department will be the respondent number 1 and 2. Department of Labor Welfare. এখনো নয় জানো, এখনো আমার নিয়ে আসবে, বেলেগ নাই। Stop করলাম।
What is this affidavit for?
Well, that is the same instruction that was furnished to the board. They filed the affidavit, this is on record already.
This one is on record.
Yes. But the
Now-
affidavit of respondent
Now,
one and two
the
will be
board,
necessary.
do you have the financial capability?
The board doesn't have that.
Then how can we ask the state to pay?
Yeah.
Because the Lordship may say initial permission, manner, they paid the 7-pay commission without the financial concurrence. But when this was came to the notice, my lord, then the 2 years they have been paid 7-pay commission, but thereafter they stopped. And because of the PMs, my lord, I'll show please some of the records, my lord. First, Lordship may say page 71, my lord.
Page?
71. So this was moved, my lord. The approval is given by the chairman, my lord. It was moved by the Welfare Commissioner, Assam Tea Employees Association. Thereafter, my lord, in Lordship may see page 72, my lord. This is, my lord, with regard to 6-pay and 7-pay commission. With reference to the above subject, I have directed to request you to submit a proposal for release of grant in aid for payment of salaries to the staff, Assam Welfare Association as per 6th-pay commission or to Labor Welfare Department immediately for sending it.
But the question is, if you get the grant in aid, are you in a position to pay them, give them the 7-pay commission?
No.
That's the answer.
Yes.
Because the state is not bound to pay.
Then within our resources, madam, we cannot. Within our resources, we cannot.
So you may have to ask for more grant in aid.
Yeah, that already budget has been given, my lord. Lordship may see the last page, my lord. Last few pages, my lord, of the. That page number 86, my lord. 85, 86. That Lordship may see first, second, on the bottom, just 4 lines above, my lord, total 32 grants in aid, general non-salary. The last, my lord, 2 line, this is page 86, my lord.
That I've seen it. Which one?
A budget, we have included budget 395, my lord, in this crore.
Which is the head of account?
Yes. The head of the account is the total 32 grants in aid, general, non-salary, then total subhead 395, total expenditure 395, madam, including the benefit of the 7th-pay commission, but there is no financial concurrence to this, my lord.
No, now you have given the requested for granting aid
Yes.
from the finance commission, finance department, isn't it? From the government,
Yes,
as per the 7 pay commission.
right, my lord.
The government have not done anything.
Not, because of the page 83 may be seen, my lord, page 83. Because that is the, because the first month of page 82 can be seen, my lord. It is written by Deputy Secretary, Government of Assam Labour Department through the Welfare Commissioner. With reference to the subject cited above, I am directed to enclose an extract of views of Honorable Chief Minister Assam, along with the order of Honorable Minister Labour Welfare Department Assam in regard to the subject mentioned above in favor of our information and necessary action. Then the next page, my lord, that now then page 60, my lord, may be seen, my lord. Page 60 is the
Mr. Goswami, you find out something by which we have to compel the government.
Only one submission, at this instant, my lord. But when we have more than 100 employees, my lord, regular employee, then my lord, they could give us the benefits of the 7 pay commission for a period of, it's not 2 years, 1 year, a year. So it becomes 3 years. Then they stop without any opportunity. That is number one. And my lord, now the employee strength is only 34. Now the employee strength is 34. On the contrary, they are reducing the granting aid. This is not understandable. And whereas, my lord, there is no distinction made, my lord, in this act, my lord, so far as the salary is to be paid. And we are.
No, whatever may be, you see.
And this enterprise, my lord,
no,
by
no,
enterprise.
Mr. Goswami, you will also have to see
Well,
the if you go through the ROP, it is categorically said that the ROP shall not be applicable unless the government allows it.
and that is.
So that is the ROP rules.
my lord.
But here, how do I compel the government to give you that? I have all inclination to do so.
Right.
But help me out.
Well, let the government come by and weigh affidavit, my lord. Then they find that affidavit is not fine.
File an affidavit.
To be from the welfare department, respondent number 1 and 2, you have to find that.
Who?
Respondent 1 and labor.
No, labor, no, finance. You are the main problem.
The revised proposal is pending with the finance department.
No, finance. Mr. B. Gogoi, who appears on behalf of the Labor Department as well as the Finance Department of the Government of Assam, seeks for some time to file an affidavit. It is also the opinion of this court that a stand of the finance would be required, taking into account the issue involved. List the matter on 7/1/2026. In the meantime, the affidavit be filed on behalf of the Labor and well as the Finance Department on or before 5th of January 2026.
Yeah, Peter Mugaos might is.
The petitioner is also given the liberty to file a reply to the affidavit filed by the respondent. Number? Mr. Roy, you are appearing for?
My 3 and 4, my.
3 and 4 is the board.
3 and 4.
All right. 27. कागजपुर एगुल ना सब
What? What is this? PNRD taken up by fire, no affidavit has been filed in time order passed earlier. What is this PNRD?
Station was short form.
Which even praying for. But she been praying for some more time to,
Who are you?
for the PNL lawsuit.
PNRD. You have not been able to, yeah.
Only station was short form.
How many dates? 1 date, 2 date? How many dates you want?
3 weeks time.
Huh?
A week's time would suffice.
Why, are they not providing you the, who has filed the affidavit? Respond number 5, who is he?
Who is newly elected as president of the Gaon Panchat, my lord. He was not there at the time of my lord enacting of act.
It's okay. The respondent PNRD, for reasons best known, have not provided with instruction to the council, to the standing council of the PNRD. It appears, therefore, in spite of the 3 dates have been given to the respondent PNRD. It therefore there appears that the which department, Dhubri Jila, therefore, who is in charge out here?
Lordship, the instructions would come from the secretary.
Huh?
Secretary.
Secretary?
Char Hatipota Gaon Panchayat. Respond number 4.
Respondent number 4.
Yes.
It therefore appears that the secretary, respondent number 4, does not want to use the services of the standing council. Accordingly, list this matter on 15th of December 2025 at 10:30 a.m. On which date the secretary, Sar Hatipota Gaon Panchayat, shall be present through the video conferencing mode. In the video conferencing mode, the link to be provided by so-and-so, the council, standing council of the Panchayat PNRD. It is observed that in the meantime, if the instructions are provided, the respondent number 4 need not appear. Interim order passed earlier shall continue till the disposal of the petition.
28. In this case also, PNRD also directly to obtain instruction.
Lordship, is instructions are awaited in this matter. Some time is given. Instructions are awaited. Some more time will be given.
Petitioners of the shopkeepers and NIT not issued there, but they are not running their business.
We call this time the secretary, PNRD department. There are council appearing on behalf of the standing council appearing for PNRD have not provided us with instructions. Inspector.
No, Lordship, sometime just would suffice.
Or Friday, get your instructions. If you don't get your instructions on Friday, we are going to call these people. I fixed it in 9 days' time because of this. We need a small instruction. Kindly just learn from these corporations, like in IOC. Didn't you see? At 2 o'clock, 1 o'clock, I asked for instruction. 2 o'clock, instructions are available. It's a simple thing. Why there no instructions are available? You are not also the standing council, no?
No, Lordship, I'm appearing on behalf
Oh, none appears on behalf of the PNRD when the matter is taken up. It is also seen that the instructions which have been sought for by this court dated 17/11/2025 is also not placed. Considering the above, list this matter on 3rd of December 2025. It is observed that if the standing council of the PNRD does not appear and provide instructions, this court shall be constrained to pass appropriate directions.
29.
এই 5-6টা মান হ'ব একেলগে না 5-6টা মান হ'ব এনেকুৱা কি লগৰ কেইটামান হ'ব নহয় এইকেইটা থাকিব এডমিশ্যনত হ'ব এইকেইটা 29, 54, 55, 56, 57. 54, 55, 56, 57, or 29. 29, 30. Yes, what is your instruction?
My lord, I am placing one. The site visit certificate, my lord, that format was not properly filled up. That's why it could not be issued. In all 6 packages.
Yeah.
But that date and all are not filled up, which is the main thing, my lord.
But
I can't help it.
but effect, my lord, to the report.
No, no date.
My lord, yes, my lord, it is not, but the, if he has submitted, my lord, his site is photograph, my lord, along with the application, my lord. Even if that maybe.
No, 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 no. The format which is given out there, which I took it up on the morning for the purpose of day. Very bad.
Visited.
Can't help it. No, I can't do anything.
My lord,
No. First of all, it seems you people are not there. Your client is not serious on this aspect. Why on earth he has not put the date, which is mandatory? See the site visit certificate. Then can't help it to you.
my lord, yes, my lord, that is a.
Where is that clause? Where is that form?
Well, it is
From-
part of the general clauses, my lord.
Huh?
Of the general clause.
No, there's the form, na? Yeah.
It's part of the
So
general-
the page 55.
55.
Date of the site visit. You have kept it blank.
But he had visited the site, my lord.
Can't help it.
My lord, kindly consider, my
No,
lord.
Mr. Hawk. I think your client now needs to learn that if he doesn't know how to read the site visit certificate, it is a very sad thing. And he's not fit to carry out any of this work. It's very sad.
The package number as well as everything, my lord, only.
Every case he has put the package, why haven't he put the date?
Well,
If the form is not there, tell me,
yes,
give me that this court can do it.
no, my lord.
This would not come even under the ambit of 2315. I can't help you. Hello, all writ petition dismissed.
My lord,
No.
is the, my lord, what I'm submitting, my lord.
Huh?
Is the package has not yet been opened, my lord.
So, no, I can't help
My lord, at least.
you. No. You see, if you had submitted, I would have done.
My lord,
But you have not submitted. No, you have not submitted the form.
It has submitted, but certificate, my lord, apparently.
The certificate is of no use, Mr.
Yes.
Mr. Hawk.
Only date was not mentioned, my lord.
That is the requirement.
Yes, yes.
Then
But
how can I help you? Tell me.
My lord, here, this is the format, my lord. This is the format, my lord, certificate. They have to countersign it, my lord. And he has submitted this.
So he cannot countersign if you don't put the date.
But they could have asked the petitioner, my lord, because they, along with the photograph and application, my lord, when the petitioner submitting that certificate, my lord, they could have also asked, my lord, to go step, since they have already acknowledged, my lord.
Mr. Hawk, I'm not sitting as an appellate authority. Na?
My lord, my lord, my lord.
Problem arises there.
Yes, my lord.
If I start interfering with this, I'll be interfering everywhere.
Yes, my lord.
Problem arises there. Now. I don't have. You came before this court. I gave you all protection.
My lord. Happy-
But the fact remains, if you have submitted and that is the reason why that document is not here.
No, my lord, I have,
No, reminder letter.
reminder letter, my lord, they have.
Reminder letter also you were there, but when did you visit? You have not put in the form because I have to hold it that they consider it to be non-ER.
This is a format, my lord, they have to countersign, my lord.
Thereafter, the contractor submitted the photographs of the site visit of some of the packages along with the reminder letter dated 24, which were received on 27/10/2025. In the meantime, another letter number so-and-so was issued from this office to the concerned contractor to submit all copies of duly filed on 27/10.
Yes, my lord.
Then after that also, if you don't submit, what can we do? Tell me.
Don't-
Where is the 27/10?
Mal-
Well, it is 2410,
2710, another document.
2710 letter is not there. Let for the 144, here submitted that certificate format as well as photograph. 124/7, 2410.
2410 you are, then they have written a letter to you. Where is the 2710 letter? I can't read.
নাই, সেইটো maximum দিব নোৱাৰো। আছে তোমাৰ চবতে আছে ন? আছে।
What do you say, Mr. Gugoi?
My lord, in fact, in page 153, in the reminder dated 24/10/25 of the petitioner, the date is not mentioned, my lord, in fact, in their own representation or the application.
150,
153,
52.
153. 1552, my lord, there is no, my lord, that photographs are not there. In 153, they submit the photograph with a reminder. But my lord, even the date of, my lord, when they visited the site, there is not mentioned, my lord, in their own representation. Page 153. Nothing has been mentioned.
It is there in the photograph. It's visible in the photograph. 24/21/10.
Show me that provision by which that form is to be submitted.
Yes, sir.
Go 7 on.
7.1, it is a page number, my lord, 39.
Shall obtain the mandatory survey with verification from EA authenticating his visit to the site and submit. Now, how does it say relate to that form?
My lord,
Page
site visit
55.
certificate.
Huh?
Site visit certificate. It shall obtain.
No, no, understood. How does it relate to the reference to clause 7.1?
Yes, it is at page 55, lordship will say.
That I've seen it.
Just mentioned. Because this certificate is part of the tender document.
Okay. And the most important is the date. Not even because package you mentioned it on top.
Is it photograph?
Now, all these repetitions. Heard Mr. S. Hawk, the learned counsel, appearing on behalf of the petitioner. And Mr. B. Gogoi, the learned additional advocate general, who, as well as the standing counsel of the PWD, who appears on behalf of the respondents number 1, 2, and 3. Taking into account that the issue involved in all these 6 repetitions, 6, na?
6, supply there, supply 4.
Hey, kita 6, soy da, bude. 6 writ petitions pertains to 29, 30, 54, 55, 56, 57. 6 writ petitions raises common question of law and fact. All are taken up for disposal by this common order. A notice inviting tender was issued dated 9/10/2025, whereby bids were invited in respect to 8 packages. The petitioner herein being interested in 6 out of the 8 packages. The details have submitted his bid. The 6 packages in respect of which the petitioner submitted bids were serial number page 19 চাই লব হা গোটেইখনত লেখা আছে হা 6টা 8টাৰ ভিতৰত which are the ones you did not out of 8? Anyways, you'll find it. Full stop. It is the requirement of the bid document of the general conditions of the instruction of the bid document, and more particularly Part A of the instruction to the bidders, that the petitioner is required to carry out the site visit of the site visit, and thereupon to obtain a mandatory site visit certificate with verification from the concerned engineer authenticating his visit to the site, and submit the same along with the bid. Clause 7 of the instruction to the bidders being relevant is reproduced herein under page 39. Thanks. It is further relevant to take note of that clause 4.3 of the instruction to the bidders stipulates what are the informations to be provided in terms with subclause N of clause 4.3. There is a requirement of submission of the site visit certificate with verification from the concerned engineer. It is further relevant to take note of that in terms with the appendix to the instruction to the bidder, more particularly clause 2H, the bidder is also required to submit along with the bid the site visit certificate with verification from the concerned engineer specified in clause 7.1. The instruction to the bidder, the appendix to the instruction to the bidders further provide the format of the site visit certificate. Wherein it is required that the bidder shall enter its name, the comma, comma, the package, then enter its name, shall enter the name of the bidder, semicolon, the name of the work as published in the NIT, as well as when the bidder visited the site. Push. The case of the petitioner herein. Now, why are here 6 means 2? You have got site visit certificates.
Yes, here visit to all the, here visit to all the site, my lord. But we here submitted bid only against 6 packages, my lord. Except.
But why did you ask for 8 site visits? Anyways. Okay.
4 and 8.
It is further relevant to take note of. That in terms with the notice inviting tender, dated 9/10/2025, the last date for submission of the bid is 3/11/2025 up to 2 p.m. The record reveals that the petitioner herein on 17/10 requested the executive engineer Nalbari to issue the site visit certificate in respect to 8 packages. Thereupon, on 24/10/2025, the petitioner sent a reminder to the respondent number 3 for requesting for the site visit certificate. However, however, it is the case of the petitioner that in spite of those communications dated 17/10/2025 and 24/10/2025, the petitioner was not issued the site visit certificate in respect to the packages, in respect to the 8 packages. The petitioner submitted bids against 6 packages out of the 8 packages, the details of which have already been provided here in above. And apprehending that the bid of the petitioner would be cancelled for non-submission of the site visit certificate, have approached this court by filing the 6 writ petitions presently being taken up. This court, by an order dated by various orders, issued notice making it returnable today. And further directed that the respondent authorities may evaluate the technical bid of the petitioner but shall not reject the bid of the petitioner on the ground of non-furnishing of the site visit certificate. Today, Mr. B. Gogoi, the learned standing counsel appearing on behalf of the PWD department, have placed before this court an instruction dated 25/11/2025, which is kept on record and marked with the letter X. From a perusal of the instruction, a perusal of the instruction reveals that the petitioner submitted letters on 17/10/2025 on letter dated 17/10/2025 and 22/10/2025, which were received on 22/10/2025 and 27/10/2025. While submitting the state's letters requesting for the site visit certificate, neither the letters mentioned the date of visit nor in the performer of the site visit certificate, which is required to be filled in with the details as has been mentioned in the notice inviting tender. The date on which the visit was carried out have not been mentioned. The site visit certificates which were submitted for obtaining the signature of the concerned engineer in respect to the 6 packages have been also enclosed to the said instruction date kept on record and marked with the letter X. From a perusal of those site visit certificates which the petitioner submitted in respect to the 6 packages, it is strange, it is surprising to take note of that the petitioner have not mentioned the date and it is kept blank. Next. It is the further instruction, it is further mentioned in the instruction that taking into account that the petitioner had kept the site visit certificate which was submitted for the for obtaining the signature of the concerned engineer. By keeping the date of the visit blank, it was not therefore possible on the part of the concerned engineer to put his signature in the said site visit certificate. In this regard, it is also mentioned that a reminder was issued to the petitioner on 27/10/2025. However, then also the petitioner did not take any steps. The reminder is kept on record. The reminder dated 27/10/2025 is kept on record and marked with the letter Y. First, taking into account that the petitioner did not submit the site visit certificate, which is required to be submitted as per the format which is mentioned in the instruction to the bidders, and there is no mention of the date on which the petitioner visited the site, it is the opinion of this court that the petitioner is not entitled to the reliefs as has been sought for in the writ petitions. Accordingly, the writ petition stands dismissed. Cost. Some cost for unnecessarily spoiling the time. What do you say, Mr.?
6 cases, madam.
6 cases, 10,000, 10 or 60,000.
Take my lord, he has visited the.
Huh?
How to make the Colombo, I don't know, my lord, but it's digital side of the photographer. But
No,
he has left the
But Mr., you see, the problem which arises is I would have helped you, but with that, if I would do one, tomorrow somebody will come that, okay, I forget to put the package, but in that I have mentioned. And you have also another very big defect which your client has done. Why is he asking by one document? Have you seen that? He has asked by one, giving 8 packages. He should have given individual.
Yes, yes.
What is wrong with you? Doesn't have so much of time or busy. So, no cost.
Your Lordship.
What is this distillery doing here?
Well, the suit was filed, suit has been filed. And there is an order of injunction passed against which this appeal has been preferred. Now-
Why the matter is before me?
Now, let me just explain it. When the matter was taken up before civil bench one,
Oh,
it was taken that
I am the commercial judge.
that is one aspect. Second aspect is that the main objection taken that appeal will not lie here, it will lie before the district court. That is to say, before the district judge. So that was the objection taken. So on the last date when the matter was listed, the honorable court was of the opinion that even if I explain the aspect, it will be your lordship's bench which will eventually have to take the decision. So that's why, my lord, it has come here.
May I state something, Your Lordship? Lordship, there are two preliminary issues that has to be decided first before the appeal can be taken up, Your Lordship. So with Your Lordship's due permission, as well as with the consent of the other side, if I may argue the matter first to raise the preliminary issues, Your Lordship.
Oh, definitely. Why not?
Your Lordship, this matter
But
is,
not today, na?
Your Lordship,
It's too late in the day.
as Your Lordship wishes.
When do you want it?
We have an urgency, Your Lordship.
You want to raise the preliminary issue.
Any date, Your Lordship.
Whichever is convenient. I am always free.
My lord, tomorrow, well, there is a,
Absolutely no.
my lord, your lordship will kindly see, my lord, the injunction order is such that my entire business has been stopped.
Your Lordship,
Practically, my lord, it has been my contention in the appeal that in the garb of interim order, my lord, the entire suit has been, it is in the nature of a decree to be passed in the suit after trial.
It was a commercial suit.
yes, Your
It
Lordship.
was registered as a commercial suit.
Then
Then, my lord, initially the suit was filed before the district judge. They alleged that there was a trademark violation. Thereafter, the opinion was exchanged that it was not to be filed there. They withdrew it, filed it before the civil judge. Now, the civil judge takes his stand to decide that it will be not before him, it should go, since trademark is involved, it should go before the district judge again. Now, thereafter, they file a review petition before the district judge, saying that the earlier dismissal should be reviewed and it should be instead remanded to the commercial court. Then the district judge reviews the order and ultimately the case comes before the civil judge senior division again. Now, civil judge senior division now decides the injunction. They say that there is an element of passing off in the entire exchange undertaken by me. So the civil judge passes an injunction which virtually affects my business, so to say that the entire business.
understood very well. Now, this is an appellate jurisdiction.
Your
Now,
Lordship,
we have come over here by.
Understood. You are exercising an appellate jurisdiction in a commercial court litigation.
Yes, there I have a submission.
So there kindly hear me also.
Yes, Lord.
I am not that court.
No, that is the objection taken by them.
Rightly so.
Yes,
Because
sir.
the court would be Justice Surana and Justice Manish.
No,
Why?
my lord, because if your lordship will kindly see the Commercial Courts Act, that division bench will be there to hear a dispute or rather hear an appeal against an order passed by your lordship. And that is conceivable in an area where the High Court will exercise original civil jurisdiction. Just as the case.
No, my jurisdiction out here is very limited in respect to
yes, Your Lordship.
but matters pertaining to the trademarks. What happens? I have the original jurisdiction only.
Yes, sir.
Because original jurisdiction in a sense that certain matters, when there are two, it's not in trademark, but it is in design or something. I
Design
forgot.
2000.
Yeah. So there, what has happened? When there is a counterclaim being filed
Yes,
by the respondent in that matter, then the district judge cannot take up the matter. Then it has to be taken up by the High Court. Then High Court, in view of the Commercial Courts Act, the High Court would then become the original jurisdiction.
Yes.
That is the jurisdiction I have.
That is one aspect of the matter.
I don't have that appellate jurisdiction.
No, my lord, your lordship's appellate jurisdiction is in respect to the order passed by the civil justice.
No, 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 no,
But
no.
now, my lord, may I just?
So you get hold of those two judges,
No, no. Well, it will not,
not before me.
well, it will not before that bench. My lord.
But I don't have I don't have the roster for that. I don't have the roster. Then if you are going to, mine is only for commercial original jurisdiction in the High Court.
So, my lord, before your lordships take that opinion, my lord, if I.
I don't need, it is already there in the, by the court.
My lord, this.
By the chief justice have constituted the bench for that.
Yes, my lord.
Your lordship, it's for the provisions of section 4(1) of the act. This is not the appellate, does not have the appellate jurisdiction to entertain this appeal, your lordship.
Now,
As per the notification, it's written out there, it's as per section 4(1) of the act, your lordship. Appellate courts have been created by virtue of section 3A and 5 of the act, your lordship. That is my first issue.
No, Mr. Counsel, I'm with you.
Yes, your lordship.
I don't have that jurisdiction. My jurisdiction is only in those
Yes, your
limited matters where the High Court
Yes,
exercises
your lordship.
jurisdiction,
Absolutely.
original jurisdiction in respect to commercial courts.
Yes, your lordship. That is my first issue, your lordship.
And my lord, now if your lordship will kindly hear my submission. What the objection has been taken is that, my lord, since it is a commercial suit, therefore the appeal will lie before the district judge under provision of 13(1). That is the
Yes,
objection taken.
rightly.
Now, my lord, to constitute it to be a commercial court, my lord, it requires a notification by the state in consultation with the High Court. Now,
There
all-
is. There is.
Yes, your
My
lordship.
lord, yes. Now, the notification which they are relying, your lordship, that is dated 13th of February 2019. It has been placed probably on.
But Mr. Dutta, I don't know why the matter is listed before me. I don't have the jurisdiction,
Now,
even to listen all these things.
my lord, let me just make my submission, my lord. If your lordship will kindly see this 13th February notification, my lord. This notification was issued under the provisions of the Commercial Division and Commercial Appellate Division of the High Court's Ordinance 2018. Now, this 2018 ordinance stood repealed by virtue of the Commercial Courts Act 2018. So after the repeal of the act, what is the enforceability or what is the implication of
But
this?
there are some other notifications.
No, my lord, I checked
Let
with
the
the
registry
registrar.
look into it. But but do I have the jurisdiction to entertain this?
No, therefore, my lord.
No, the
well,
question is why the matter is before me.
Possibly,
On the last date, your lordship,
my lord, possibly the honorable court has formed an opinion that it is a matter which needs to be decided by your lordship. Your lordship may at least.
No, has been pleased to constitute a commercial division of the Guwahati High Court comprising of so and so. Commercial division, there is no division. I don't have appellate jurisdiction. It will go before that court.
My lord, then it should actually, my lord, that is the idea why it was registered as FAO. Because since there is no commercial court constituted under section 3(1), therefore, the general provisions will apply and therefore order 43 rule 1R has been invoked. It cannot be construed to be a commercial appeal as such. That is why it was listed before civil bench 1, but the honorable court had formed an opinion that since there is a bench constituted with your lordship, so therefore the matter needs to be heard here.
Who gave that opinion?
My lord, your lordship.
Where is the order?
Last order, my lord, 2020. Day before yesterday. And as far as I could check with the registry, my lord, barring this 2019 notification, there is none.
But the problem is,
And this notification is of no consequence because the ordinance stood repealed in the year 2018 itself.
no, Mr. Dutta, I would have loved to take up the matter, but do I
Well,
have the?
I will also ask before your lordship that your lordship.
I cannot. I cannot.
Well, otherwise.
After getting a lot of non-payment of non-payment of dues, issues and tenders and all, it would be refreshing for this court to take up this affair.
Tomorrow, Kindly hear it. and-
No, but the fact remains that I don't have the jurisdiction.
Well, your lordship will not be exercising jurisdiction under Commercial Codes Act. My submission is that it has the honor.
Then to more, I don't have the jurisdiction.
In, well, it has to go, in my understanding, my lord, as I have understood the fact, from the facts of the case.
No, no, no. but
it
First,
has
no,
to
no.
go-
The reason why I'm saying is, I don't have the roster for civil bench one. You have to understand that.
Civil bench one, the civil bench one says that I should come before your lordship, my lord. I am caught in a fix, my lord.
Your lordship, the,
My understanding is that it will be an appeal under
Okay.
43(1).
your lordship, the appeal is against an order.
Wait. Let me solve it.
Lordship-
Let us put this in the head of the Chief Justice and let him decide. Why should I take all these things? Okay. The instant first appeal has been listed before this court, before me, pursuant to an order passed by the learned coordinate bench dated 24/11/2025 on the basis of a notification dated 2/6/2025. Full stop. The present appeal is directed against an order of injunction
Yes,
passed by
Civil Judge Senior Division 3.
by a commercial court of original jurisdiction. That is the Court of the Civil Judge, Senior Division Number 3,
One.
1, Kamrup Metro at Guwahati,
Jorhat.
at Jorhat. Full stop. This court is full stop. This court directs the registry to place the matter before the Chief Justice as to whether this court can, and whether this court, who is presently taking up the roster of bench 4, would be in a position to deal with the appeal. Full stop. The registry shall accordingly list the matter on Friday after shall accordingly list the matter, keeping in mind that that the counsel appearing on behalf of the appellant expresses utmost urgency in view of the fact that on the basis of on the ground of an on the ground that in view of the interim order injunction, the very business of the appellant have ceased to operate.
Your lordship, this
On
matter
Friday,
has
sir.
been listed.
Man,
No, not,
I cannot. You see, I cannot say that it will come because then I would. I need another 6 years.
I wish it would have happened within 6 minutes.
No, 6 years. Yes, what is this?
Yes, my lord, I've sought for further clarification from that is awaited, my lord. I pray for some time to file my affidavit. Otherwise, my lord, as per the regulation 5.8.3.2C, the dues payable by the previous owner are recoverable from the new owner, my lord.
No, this is a case pertaining to one person. Okay. So here it was in the name of somebody else.
Else, my lord.
And you have disconnected, taking into account that person left.
Yes.
And they are somebody, they have
They
their
are the
own
new,
connection.
as per the instruction, they are the new owners. They are the new owners. So I need further
So
clarification
if
that.
they are the new owners,
Yes.
they cannot own the electricity.
No, my lord, the charge payable by the previous owner shall be recoverable from the new owner, my lord. So that's why the bill is served to them, my lord.
This is permissible as per that.
Yes, my lord.
Why you are not filing affidavit then?
Because, my lord, on the instruction that I've received, my lord, the previous owner that
based on some information received from the neighbors, my lord. That is some, I need further clarification. That's why.
Then
asked.
he can't.
Yes, my lord.
So it is on in cloud nine. Hello. Mr.
B das, my lord.
Bidas appearing on behalf of the APDCL 6 for some time for filing the affidavit. This the matter again on 7th of January 2026. Interim order passed earlier shall continue. Full stop. It is further observed that the interim order earlier I have mentioned subject to payment
Yes,
of
ma'am.
shall continue till the next date. Yes, any urgency, anybody?
53.
The bar says that I should not sit beyond the time, so therefore I'm asking,
The settlement.
any urgency? Yes.
Yes, respondent will official respondent will file executive.
What is your matter about?
Milord, in violation of the clause 112, 15, 16 and 18, Milord, I settle the market with the private respondent.
Okay, but I have passed an order against you. I passed an order against you in another matter where I have held that if there is no settlement for the last 3 years, then you can't apply clause for rule 47(1) as well as clause 12 of the NIT. It is your case is that. So was there any further notice pursuant to the notice issued by you see my order. I passed an order of in the case of Mr. Kane Chaudhary, there's one case. Hey, just give it to him. You take it. And on that day we'll dismiss it. Not today.
The private respondent, tender is defective tender.
Why?
Milord, he has not submitted 2-3 documents.
But understood. But you are further, your bid cannot be taken into consideration. How can you be valid if it goes beyond the 10%?
Yes, I am.
How much did you quote?
Yes, after 10%, Milord, I am the highest bidder, Milord.
No. What is your quote? Petitioner herein he has quoted 17 lakhs here, which is within 10%. However, the respondent has quoted 2104. And what are the other grounds?
Other grounds, Milord, as per clause 1, 12, 15, 16 and 18 of the NIC, Milord, can you see page 16, 1/6.
What?
1, 12, 15 and.
10% is gone. No problem with that. Required to submit the 15. He has not submitted a fixed deposit.
Yes, he has not submitted fixed deposit, Milord. He has submitted the documents 2020.
Okay, none has appeared for the PNRD, na? Hey, I don't recognize him. So none is okay. None has appeared on behalf of the PNRD on call. So considering the above, list this matter on 3rd of December 2025. If it is observed that if none appears on the next date, this court shall proceed with the shall have to pass appropriate orders. Any urgency? No urgency?
Madam, there is a contempt case. We are the respondents. We have complied the order. We're going to close this case. Item Iman Ali to question.
You have complied?
We have complied, my lords.
Which
There
one?
was surrender application. He is there, my lords.
Item number?
Item 36. my lords.
I have no
36.
problem in taking up the matter till 5 o'clock, but I won't dismiss or pass any judicial orders against him
36, my lords.
if the parties are agreeing. Huh?
Ekon-
Item number?
36. He had referred a surrender application of a mining area accepted by government.
Should have taken a final decision, Lord.
You have already?
With respect to the security deposit which was forfeited.
Hereby accept the surrender application of the petitioner in respect of Borapandi so and so due to his inability to paying his postman. Then,
The security deposit was forfeited, Lordship. With respect to that, they have not given any clarity. Whether that will be released on the Lordship.
no, was it a part of that order?
Because that he.
No, what was the order passed? No, item number 36 to the.
Page 17, man, the cooperative part.
What is the direction? Let us see.
Shall take a final decision with regard to petitioner's application for surrendering the Borpani permit area.
Wait. Where is the, yeah, impute.
Page 17 of the petition.
In terms with the judgment of apex court, the petitioner is given prior notice before he is blacklisted so and so, as no notice was issued to that so and so. Any subsequent sayer does not withstand the scrutiny as it is violative of in view of the reasons the office order dated being set aside. So is set aside in respect of what?
Blacklisting was set aside,
aside.
interfered, my lord. But
Huh?
direction, blacklisting was.
So the forfeiture has already been interfered with.
Lordship.
So what is there?
Now there was an order, Lordship.
No.
Where is that order? The House shall take a final decision with regard to the petitioner's application dated for surrendering it. So that has been done.
That has been complied with.
So there is no order for giving you the money. You file something
Lordship.
if you have. Well, it is seen, Mr. D. Gogoi, the learned, so this is an application, heard Mr. So-and-so appearing on behalf of the petitioner and Mr. D. Gogoi who appears on behalf of the respondent number.
My lord, I appear on behalf of all respondents.
All the respondents. So this is an application filed alleging willful and deliberate violation to the order dated 8/5/2023 passed in WPC number 2432/2023. From a perusal of the said order, it is seen that this court, the learned coordinate bench of this court, not only interfered with the office order dated 36 dated office order number 36 dated 15/3/2023, but also directed the state respondents to take a final decision with regard to the petitioner's application dated 31/2023 for surrendering the Borapani Sand Permit Area number 1B. Full stop. Mr. D. Gogoi, the learned counsel, submits that on 25/11/2025, the officer in special duty on environment, forest and climate change have intimated the principal chief conservator of forest and HOFF, Assam, that the environment, forest and climate change department government of Assam accepted the surrender application of the petitioner in respect to inverted comma Borapani Sand Permit Area number 1(B) inverted comma closed due to his inability in paying the kist money. The said instruction is kept on record and marked with the letter X. In view of the above, nothing further remains in the instant contempt application. Accordingly, the contempt proceeding stands dropped. Before parting with the record, this court finds it relevant to make an observation in view of the submission made by Mr. So-and-so appearing on behalf of the petitioner, that the petitioner is entitled to the refund of the security deposit which have been forfeited in view of the order dated 8/5/2023 in WPC number 2432/2023. It is the opinion of the court that that aspect is not the subject matter of the present proceedings, and the petitioner herein, if so advised, would be at liberty to initiate such proceedings otherwise available in the law.
Perhaps that not be needed because we can defend that forfeiture.
He is asking. I have to answer that.
If that finding is given, my lords,
Is not a subject matter of the instant proceedings. Liberty, however, would be there upon the petitioner to approach the respondent authorities for release of the security deposit, and if not granted, the petitioner would be at liberty to approach this court. What is that? Affidavit regarding the stay has been received and is at flag so and so. Affidavit in opposition 3 is filed. The option 59-2.
Already I have taken justice service, again I respond now follow. Madam, I listen for admission.
Huh?
Already I have taken justice service, Lordship.
Lordship, I am appearing on behalf of respondent number 4. We have filed our Wakalatama yesterday, Your Honor.
Then all are appearing?
All are appearing.
Okay, taking into account that the service upon the respondents are duly complete, list the matter
Like next club.
Lordship, any date after 6th of December, Your Honor. Lordship,
on
any date after 6th of December.
8th of December.
Lordship.
Is there interim order?
No, Lordship.
Is there a consideration of an interim order?
Yes, Lord.
Gustav, on the next date, this court shall duly consider as to whether the petitioner would be entitled to any interim order.
Much obliged.
What is 60? 60?
Yes, sir. Interim is there, Lordship. Today,
Service complete
today file Lordship just a affidavit.
against respond number 2 and 3.
Then,
Okay. List this matter, taking into account that the Ms. So-and-so appearing on behalf of the petitioner submits that affidavit of dusty have been filed. List this matter on 10th of, on 10th of December 2025, along with the affidavits of service so filed. Interim order passed earlier shall continue till the next date.
Item 33 also, the interim order to continue.
Huh?
Item 33 also.
32, 33.
32,
32
33
is the
is a
contempt, my
contempt.
lord, wherein in the contempt petition, my lord, a advertisement has been made in paragraph 10 of the contempt petition that after the repetition interim order, wherein it was directed not to make payment to the private respondent 6 and 7. I have taken the instruction with regard to paragraph 10. The last payment was made to the respondent number 6 and 7 on 13/5, whereas interim order is dated 27/5. So there is no contempt as such.
Lordship, in this particular case,
You
the-
put it on affidavit?
Yes, I do.
Mr. A.K. Bhuya, appearing on behalf of the respondent contemner, submits that he has that the respondent contemner would like to bring on record an affidavit. List the matter, how much time?
Any day, my lord.
List the matter again on 10th of December. In the meantime, the affidavit be filed on or before 8th of December.
Yeah.
32, 33 double day to 33 to AK logote aibo list the matter along with contempt case number 484/2020.
33 interim order to continue. Lordship.
Interim order is there, na? 33 to WBC, the interim order passed earlier shall continue till the next.
Obliged.
Anything more? Yes.
Item note 39, Lordship, I am praying for fixing a date. Lordship is order dated, non-compliance or order dated 11/3/2024, Lordship. Lordship, 11/3, they have not filed.
Lordship, the officer concerned, who is a party here, he got transferred about 6 months back. I'm appearing for him. The new incumbent is not here. I have some difficulty to file the affidavit on his behalf, my lord. He is no longer here, my lord.
Who is the department?
The Commissioner, Food Public Distribution and Consumer Affairs.
Mr. See, when it comes to punishment, we will definitely bring the new incumbent. You are also a senior government advocate. Take it up as to why it has not yet been complied with. Don't go into all these things. Whenever it is a punishment, we will inform him. And we will only inform him that why we should not punish you for complaint. So don't worry with that, who is there or not. And you being in the government can very well take that instruction. I would have understood that you have a private counsel, it may be difficult. You may not have a touch, but you have a touch. Find it out. We need you see, at the end of the day, Mr. Nanath, we need a compliance.
Correct.
If there is no compliance, unless it is next to impossible for you to comply. That's another aspect.
Well, Lordship.
Okay. So
Lordship
when
may-
do we have it?
Lordship may keep it after 3 weeks, madam. Lordship may keep it after 3 weeks, my lord.
2 weeks.
3 weeks, my lord.
3 weeks, then it will be after vacation.
Not your lordship.
Before vacation? Let's try our luck.
After,
See the agony of the face of Mr.
Lordship.
Kolita,
Lordship.
Similarly,
waiting till 5 o'clock to get an order.
My lord.
And you say that will come after vacation.
Lordship.
Okay. Item number, what is that?
39.
39. 39 lists the matter again on 15th of December 2025. In
Lordship.
the meantime, the present incumbent, what?
Of, my lord, the Commissioner, Public, Food Public
Present
Distribution,
incumbent,
Consumer
who is the
Affairs.
commissioner?
Civil supplies and consumer affairs.
No,
and
no.
Legal matter.
Now it is Food Public Distribution, Consumer Affairs and Legal Metrology, Assam.
Shall file an affidavit as to why the order dated
11/3/2024. 11/3/2024.
passed in
Passed in WPC number 1545/22.
have not yet been complied with. You just find out that
My lord.
there are
Lordship.
anything